seated. Good morning. This is the 2 a.m. initial appearance hearing calendar for March 4th, 2026. The court's orders for taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. As you just heard in the recording, this is a very specific type of hearing. I will tell you why you are here, if an attorney has been appointed for you, when and where your next hearing will be, if you are eligible for release, what your release conditions are, and any bond amount required. I will not read all the release conditions to each of you. That is your responsibility to review, but I may point out a few depending on your case. You're all here today on criminal matters. That means you do have the right to remain silent. Anything you say or do may be held against you. This hearing is being recorded and broadcast live. I will only ask you for your name and your date of birth. Because the hearing is live streamed, there may be victims viewing, so I will read the victim rights advisement, and then we will begin the hearing. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law, that among others include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. We'll now begin the hearings. I'll call you in one at a time. When it's your turn, please come to the podium in the center of the room and speak into the microphone. I will call a second person's name to have a seat right there by the door so that we can move quickly. I may need to pause the hearing from time to time to handle a warrant, so please do not enter the hearing room unless you have been called. Just remain seated. After your hearing, you will be provided with paperwork, and on this document, we'll have the important information that I'm about to tell you, the dates, times, and phone numbers that you might need. Matthew Shelton, please come to the podium, and then Carlos Martinez, have a seat by the door. Please say your name and your date of birth.
Matthew Shelton, 1789.
Thank you, sir. You're here today on a probation violation warrant. It was alleged that you violated terms 3 and 5 of your probation. An attorney has been appointed to assist you, and your next hearing is downtown Phoenix on March 11th at 8:30 in the morning. You are not eligible for bond today under the Arizona Criminal Rule 7.2c, so you will stay in custody until the hearing on March 11th. Please take your paperwork and have a seat. Carlos Martinez, please come to the podium. Demoni Martinez, have a seat by the door. Please say your name and date of birth.
Carlos Martinez, February 23rd, 1996.
Thank you, sir. You're here today on 3 matters. The first one is an arrest warrant that is alleging in April of 2025, you may have had narcotic drugs in your possession. That's a Class 4 felony. The state has brought charges against you. This court is appointing an attorney to assist you. Your next hearing will be downtown Phoenix on March 10th at 8:30 in the morning, and you are eligible for release on this new matter of $1,000. I do understand, though, that you are in custody, and I note that you may be eligible for release as of April 2nd, so that's why bond is still being set. Just don't pay it, though, until you become eligible.
Okay.
All right, your next 2 matters are probation violation warrants. So anytime there's a new alleged violation of probation, you do get a term 1, and that means an attorney has been appointed for both your probation cases. You now have hearings set March 11th, 8:30 in the morning, downtown Phoenix. And because I don't want you to miss Your hearings, I set $50 placeholder bonds on those, so you'll be transported to your hearing if you're still in custody.
Okay.
All that information is on your paperwork. Please take your paperwork. Damoni Martinez, please come to the podium. Leah Irizarry, have a seat by the door. Please say your name and date of birth.
Damoni Martinez, June 14, 2002.
Thank you, sir. You're here today on a grand jury warrant alleging aggravated assault with a deadly weapon, which is a Class 3 felony. It may have happened in August of 2023. So the grand jury found probable cause and issued a warrant for your arrest. This court is appointing an attorney to assist you. Your next hearing will be downtown Phoenix on March 11th at 8:30 in the morning. You are still eligible for release. It is under a $20,000 secured appearance bond with an electronic ankle monitor. If you're able to post that bond, make sure to tell pretrial services about any obligations or commitments that you have, and then follow the release conditions carefully, and they include no contact with any alleged victim, witnesses, or complainants. If you're not able to post the bond, you will stay in custody and be transported to your next hearing. Please take your paperwork, sir. And we will need to pause for just a moment while I handle a warrant. Okay, we will resume. Leah Irizarry, please come to the podium. Trayvon Platt, have a seat by the door. Please say your name and date of birth.
Leah Irizarry, 4792.
Thank you, ma'am. You're here today on an arrest warrant. It is alleged that you had narcotic drugs in your possession back in April of 2025. That's a Class 4 felony. The state has now brought charges against you. An attorney has been appointed to assist you. Your next hearing is March 10th at 8:30 in the morning, downtown Phoenix, and you do have a secured appearance bond of $1,000. If you're able to post the bond, make sure you go to your hearing. If you're not able to post it, you'll stay in custody and be transported to your hearing. Please take your paperwork, ma'am. Trayvon Platt, please come to the podium. Ethan Holliday, have a seat by the door. Please say your name and date of birth.
Trayvon Platt, 128-2000.
Thank you, sir. You're here today because of a probation violation warrant. It's alleged you violated terms 3 and 5 of your probation. An attorney has been appointed to assist you, and your next hearing will now be March 11th, downtown Phoenix. It's at 8:30 in the morning. You are eligible for release. It is under a secured appearance bond of $750. If you're able to post the bond, make sure you follow your normal terms and conditions of probation. Call your probation officer, go to the hearing. If you're not able to post that bond, you'll stay in custody and be transported to your hearing. Please take your paperwork, sir. Ethan Holliday, please come to the podium. April Lewis, have a seat by the door. Good morning, sir. Please say your name and date of birth.
Ethan Holiday.
And
72497.
Okay, thank you, sir. You're here today on 4 separate matters. The first one is a new case. In your new case, it was alleged you had drug paraphernalia in your possession. That is a Class 6 felony. This court found probable cause and appointed an attorney to assist you. Your next hearing on your new case is on March 10th at 8:30 in the morning. There is a $50 placeholder bond set in your new case because you have other outstanding warrants that carry higher bonds. So this will ensure that if you can't pay those, you'll still be transported to your hearing and not get a failure to appear. Your next matter here today is a probation violation warrant. It's alleging that you violated terms 3 and 5 of your probation, and actually you have all 3 of your other matters are the same. They're the probation violation warrants. So an attorney has been appointed to assist you in all 3 of those cases. Your next hearing is downtown Phoenix, March 11th, so the following day, and that's at 8:30 in the morning. They do carry varying bonds. One is $250, the other one is $150, and the last one is $150. So altogether, with all your bonds, it is $600 secured appearance. If you're able to post that bond, make sure you go to court both days, the 10th and the 11th. Call your probation officer, follow your normal terms and conditions. If you're not able to post those bonds, you will stay in custody and be transported to both your hearings.
All right, so what's today's date?
Today is the 4th of March. All right, please take your paperwork, sir.
Where?
Your paperwork right over there, sir, and follow the officer's instruction. April Lewis, please come to the podium. Kejuan Pierce, have a seat by the door. Please say your name and your date of birth.
Angela Lewis, 10/27/94.
Did you say 10/27/94?
Yeah.
Okay, we have a different birthday for you. And is your name April Lewis?
No.
Your name is not April Lewis?
No.
What is your name?
Angela.
Anna?
Angela.
Angela. Okay. Please have a seat, and we'll come back to you. Okay, I see on the Form 4 that they have a different name.
Yeah, it's sort of the same person's name, but it's just the first name.
But the date of birth is also different. On the Form 4, they have the correct one that she just said, but on the IA detail, it is not correct. Yeah, that's what it says on the Form 4, but on the release order, it doesn't have that day. It has a different birthday. So we can take a few minutes and sort that out. I'll keep going in the calendar, and we'll come back to her. Okay. All right. Kejuan Pierce, please come to the podium. Shailika Rain Goldtooth, have a seat by the door. Please say your name and date of birth.
Kejuan Pierce, 3303.
Thank you, sir. You're here on an arrest warrant. It is alleged that in June of last year, you may have discharged a firearm within the city limits, and that's a Class 6 felony. The state has now brought charges against you. This court is appointing an attorney to assist you, and your next hearing will be downtown Phoenix on March 19th at 8:30 in the morning. This direct complaint did ask for bond, but the court is going to go ahead and release you under supervised release because we've seen that you have 0 failures to appear. So make sure you keep following the process and going to all your hearings. All right? So you're going to be released today under pretrial services. Looks like you also have a probation officer, so make sure to follow those terms and conditions of probation. Check in with them within 72 hours and go to your hearing.
Okay.
Please take your paperwork, sir. Are you checking on the birthday? Okay, thank you. Shaquila Rain Goldtooth, please come to the podium. Adrian Cabrera, have a seat by the door. I think Miss Goldtooth might be asleep.
Who's that?
Goldtooth, she is already dressed out. Thank you. Good morning, ma'am. Please say your name and date of birth.
Angela
If you could speak into the speaker, I can't hear you, I'm sorry. All right, so I'm going to ask you, and you can say yes or no. Is your birthday August 9th, 1996? You have to say yes or no. Okay, thank you, ma'am. So you're here today because of allegations about having drug paraphernalia in your possession, which is a Class 6 felony, and criminal trespassing, which is also a Class 6 felony. This court did find probable cause and appointed an attorney to assist you. Your next hearing is going to be downtown Phoenix on March 19th at 8:30 in the morning, and you are eligible for release today. You're going to be released under supervised release. That means you do have to stay in touch with pretrial services. You're not to go back to the scene of the alleged crime, so where you were arrested for trespassing, and you're not to have any contact with the alleged victim, witnesses, or complainants. Make sure you go to your hearing or they will issue a warrant for you that does carry bond. Okay? Please take your paperwork, ma'am. Adrian Cabrera, please come to the podium. And then Sierra Beach, have a seat by the door. Please say your name and date of birth.
Adrian Cabrera, May 15, 1987.
Thank you, sir. You're here today on a new justice court alleging disorderly conduct or fighting as a misdemeanor. An attorney has been appointed to assist you because this might be a possible domestic violence case. Your next hearing is at the White Tank Justice Court on March 24th at 9:30 in the morning. You are going to be released today under supervised release, and you're not to have any contact with the alleged victim, witnesses, or complainants. The Form 4 indicated that the alleged victim will not be at the residence. So you may return to the residence as long as the victim is either not there or if the alleged victim consents to you also living there. If at any time the victim does not consent, revokes, or she is there, you must immediately find an alternative residence and bring proof of that to your next court date. But you are allowed what's called a civil standby with law enforcement, which means call them first. They'll escort you there to get necessary things like medication, identification, or clothing. But from what I read in the law enforcement report, she didn't plan to be there anymore. Okay? Do you understand?
Yes, I understand.
And you can follow those orders?
Yes.
All right. Then you're going to be released in a few hours. Make sure you go to that White Tank Justice Court hearing.
Okay.
All right. Please take your paperwork. Sierra Beach, please come to the podium. Rigoberto Rose, have a seat by the door. Please say your name and date of birth.
Sierra Beach, 1902.
Thank you, ma'am. You're here today on 3 matters. The first one is a new case alleging that you had drug paraphernalia in your possession. That is a Class 6 felony. This court did find probable cause and appointed an attorney to assist you. Your next hearing is March 19th, and you are being released today on your promise to go to that hearing, and you're going to be supervised by your probation officer. So your other 2 matters here today are Term 1 allegations or violations of your probation. Anytime there's new alleged criminal activity, that does trigger a Term 1 case. So you have an attorney appointed for you in both of your probation cases. Your next hearing will be March 11th, so that is much sooner, 8:30 in the morning. Again, you are going to be released today to be supervised by your probation officers. So make sure you call them when you're released in a few hours and let them know what's going on and when your next court dates are.
Okay.
All right, please take your paperwork, ma'am. Oh, okay, good. Okay, that's good. Thank you.
She's going to attach something.
Okay, I appreciate that. Rigoberto Rose, please come to the podium. Please say your name and date of birth.
Rigoberto Rose, 1962.
And is it December 10th?
December 10th, 1962. Okay. Sorry.
No, it's fine. Thank you, sir. You're here today on a new case. It's alleged you had dangerous drugs in your possession and narcotic drugs in your possession. Those are both Class 4 felonies. This court did find probable cause and appointed an attorney to assist you. Your next hearing will be downtown Phoenix on March 19th at 8:30 in the morning. You are going to be released today on your promise to go to that hearing. Between now and your next hearing, do not possess any weapons or drugs without a valid prescription. Make sure you go to your hearing or they will issue a warrant for your arrest that does carry bond. All right, please
Yes.
take your paperwork, sir.
Thank you, ma'am.
And then we'll call back April Lewis or Angela Lewis. Please come to the podium. All right, thank you for your patience, ma'am. We were able to confirm that we have the right warrant because we do have the print. So please say your name and date of birth.
Angela Lewis, 10/27/94.
All right, thank you. And that is what is written on the release questionnaire or Form 4 is Angela Lewis, 10/27/1994. So there is a warrant because you failed to go to your probation revocation arraignment hearing on November 26th of last year. You already have an attorney in that case. Your next hearing will be downtown Phoenix on March 11th at 8:30 in the morning, and you do have bond set for missing that hearing. It's $150 secured. If you're able to post that bond, make sure you follow your normal terms and conditions of probation. Call your probation officer, go to your hearing. If you can't post the bond, you'll stay in custody and be transported to your next hearing. Please take your paperwork, ma'am. Thank you. Okay, and now we have Jesus Rodriguez Sanchez. Please come to the podium. After that will be Eduardo Alonso. Please have a seat by the door. And we have a
Yes, Marita Chikwesi.
All right. Something is touching your microphone. We can hear a lot of static every so often. Okay. All right. Good morning. Yeah. So my name is Commissioner Gentry, and I need to ask you if you will swear or affirm that you will directly translate my words from English into Spanish and the defendant's words from Spanish into English exactly as we say them.
Yo juro interpretar las palabras de inglés a español y de español a inglés. Yo juro, precisamente. I do.
Thank you. Please wait for the interpreter to finish speaking before you speak.
Por favor, esperar para la intérprete terminar de hablar antes que usted hable.
Please say your name and your date of birth.
Por favor, diga su nombre y fecha de nacimiento.
Jesús Rodríguez Sánchez, 2007. 24 de marzo.
24th of March. ¿Qué año?
2007.
2007.
Okay. Thank you. You are here today on a new case.
Estás aquí hoy en un caso nuevo.
It is alleged you had narcotic drugs in your possession for sale, which is a Class 2 felony.
Está alegado que usted tenía posesión de narcóticos para vender. Esto es nivel 2 y una de felonía.
An attorney has been appointed to assist you.
Está asignado un abogado para asistirle.
Your next hearing is downtown Phoenix on March 10th at 8:30 in the morning.
La próxima audiencia será en la villa de Phoenix el día 10 de marzo a las 8:30 por la mañana.
You are eligible for release under a cash-only appearance bond of $100,000.
Está elegible para estar liberado sobre una fianza And please, can you repeat the amount?
$100,000.
$100,000.
If you post that bond, you will have electronic monitoring with curfew restrictions.
Si pague esa fianza, va a tener restricciones electrónicas y horarios limitados.
You will also need to surrender your passport at your next court hearing.
También tendrá que entregar su pasaporte a la próxima audiencia.
If you cannot post the bond, you will stay in custody and be transported to your next hearing.
Si no puede pagar la fianza, va a quedar en custodia y transferido para la próxima audiencia.
Okay. Please take your paperwork and follow the officer's direction.
Por favor, llevar sus hojas, papeles y seguir el oficial.
Okay. Eduardo Alonso, please come to the podium.
Venga al podio, por favor, Eduardo Alonso.
Please say your name and your date of birth.
Diga su nombre.
Eduardo Cisneros Alonso.
Eduardo Cisneros Alonso, fecha de nacimiento, por favor.
13 de agosto de 1990.
13 de agosto.
Sí.
8. Gracias. 8/13/1990. 90.
You are here today on a new case.
Está aquí hoy en un nuevo caso.
It is alleged that you committed burglary in the second degree, that is a Class 3 felony.
He alegado que hizo un robo en el segundo grado, es nivel 2 de la ofensa, en clase 2, el nivel.
It's a Class 3 felony.
Es clase 3 de felonía.
Also, aggravated assault, which is a Class 3 felony.
También asalto agravado y es clase 3 también.
Also alleged simple assault and threatening, which are misdemeanors.
También son delitos menores de amenaza de asalto y asalto simple.
An attorney has been appointed to assist you.
Asignaron un abogado para ayudarle.
Your next hearing is downtown Phoenix, March 10th at 8:30 in the morning.
La próxima audiencia es el 10 de marzo en la villa de Phoenix a las 8:30 por la mañana.
You are eligible for release with a cash-only bond of $25,000.
Si está elegible para estar liberado, si pague la fianza de $25,000.
You would also need to have random testing for illegal drug and alcohol weekly.
También tiene que hacer pruebas para alcohol y drogas semanales.
Okay. You would have an electronic monitoring device.
Va a tener un aparato electrónico para monitorar.
Okay. You are not to contact the alleged victim.
No puede tener contacto con la víctima alegada.
And you are cautioned that if you are to have any contact with the alleged victim, if you are in custody or out of custody, it could be considered a new felony.
También, advertencia. Si tenga contacto durante el tiempo que está en custodia o fuera de custodia, puede ser un nuevo caso de delito menor.
If you are not able to post your bond, you will stay in custody and be transported to your next hearing.
Si no puede pagar la fianza, va a quedar en custodia y le transportarán para la próxima audiencia.
Okay. Please take your paperwork and follow the officer's directions.
Gracias.
Llevar sus papeles y seguir las direcciones de los oficiales.
Okay. Ms. Translator, thank you very much for your service to the court. That was our last Spanish-speaking defendant.
Thank you for calling Lionbridge 1508. Thank you. Have a great day.
We do still have a few more people to speak with. I will read in the house calls, and then we'll call Cesar Guevara Batista. So for house calls today, we are going to go see Mr. Cordell Piet Noble. He is Nazwa, date of birth 1/27/1998. He does have 5 cases. We'll begin with the new case. His new case alleges dangerous drugs in his possession, Class 4 felony, drug paraphernalia, Class 6 felony, disorderly conduct fighting, and not giving his true name, alleged as misdemeanors. An attorney has been appointed for him. His next hearing is March 10th, 8:30 in the morning. And because he was on felony release in one of his other cases, he's not eligible for bond today, and so he had us have a bail eligibility hearing set for March 10th at 1:30 in the afternoon. So, going back to some of his older cases, he has a failure to appear bench warrant for a status conference he missed on January 22nd, already has an attorney in that case, and his next hearing is March 10th, 8:30 in the morning, and a $1,000 bond has been set. His next matter is, again, a failure to appear. This one's for a probation non-witness violation hearing, also on January 22nd of this year. Again, he already has an attorney, and a $1,000 bond is set. His hearing is set for March 10th, 8:30 in the morning. His next matter is, again, probation violation non-witness hearing. And then so is the other one. So he has 3 of those, and they all carry a $1,000 bond, but I will explain to him not to pay those bonds until after his bail eligibility hearing. So altogether, he has $4,000 in bond, but he's not eligible for release due to his on felony release when he incurred a new allegation of a felony. The next individual is Justin Cole, and he's arguing with the officers. So his date of birth is 1/26/1988. He's here on a municipal court warrant for extreme DUI. This is not his first time, though, so he's not entitled to a court-appointed counsel because now it is a failure to appear issue. He is going to have a hearing down at Goodyear Municipal Court on March 18th at 1 in the afternoon. He'll be released to OR as soon as he is safe to do so. And then the last person is Arissa Salazar Zamora, and she is unable to function. She has a new case in Superior Court. It's alleging dangerous drugs and drug paraphernalia. An attorney has been appointed for her. Her next hearing is March 19th, 8:30 in the morning. She's also going to be released on her promise or on recognizance to go to that hearing. And she does have some release conditions, including not to return to the scene of the alleged crime where she was trespassing when they picked her up with these drug allegations. So it is not my intention to return to this recording. If there are any changes, it will be made on the written orders. Cesar Guevara Bautista, please come to the podium. Please say your name and date of birth.
Cesar Guevara Bautista, and then 12/23/98.
Thank you, sir. You're here today on a new case. It is alleged that you committed 1 count of sexual abuse, which is a Class 5 felony, as well as 1 count of unlawful tape recording of a person, which is a Class 5 felony. So based on the law enforcement report, this court did find probable cause and appointed an attorney to assist you. Your next hearing will be downtown Phoenix on March 10th, and that is at 8:30 in the morning. You are eligible for release, and it is under a cash-only appearance bond of $150,000. That was the state's recommendations, and due to the nature of these offenses, this court did find that that was a reasonable amount. If you're able to post that bond, you would have electronic monitoring with a curfew, so you would need to let pretrial services know where your obligations and commitments are, so they could program that in.
Okay.
And then you're not to have any contact with the alleged victim, witnesses, or complainants. Between now and your next hearing, do not have any weapons, drugs, possess, or consume any alcohol. If an order against harassment is issued against you, be sure to comply with that court order. If you're not able to post the bond, you will stay in custody and you will be transported to your next hearing, but that no victim contact order still applies, and you are cautioned if you were to violate that, you could incur another Class 6 felony, which is aggravated harassment. All right, please take your paperwork, sir. This was our last matter for the 2 a.m. initial appearance hearing calendar, so the initial appearance hearing calendar is in recess until 5 a.m.
All right.
Please be seated. Good morning. This is the 5 a.m. initial appearance hearing calendar for March 4th, 2026. The court's orders for taking of DNA and fingerprints that were given on the first calendar of the month shall apply to all matters on this calendar. As you just heard in the recording, this is a very specific type of hearing. I will tell you why you are here, whether an attorney has been appointed for you, when and where your next court hearing will be, if you are eligible for release, and what your release conditions and bond amount might be. I will not read all your release conditions to you. That is your responsibility, but I may point out a few depending on your case. You're all here today on criminal matters. That means you do have the right to remain silent. Anything you say or do may be held against you. I will only ask you for your name and your date of birth. These hearings are being recorded and they are being broadcast live. So I will read the victim rights advisement in case any victims are watching, and then we'll begin with the hearing. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law, that among others include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. We'll now start the hearings. I'll call you in one at a time. When it is your turn, come to the middle of the room at the podium and speak into the microphone. I'll call for a second person. Please sit in the chair right there by the door. That way we can move quickly. Once in a while, I may need to pause the hearings in order to handle warrants. So please do not enter the hearing room unless you have been called. Just remain seated. Once you leave the hearing room, you will be given paperwork that has all the information listed out on it that I'm about to give you. The dates, the times, the addresses, and phone numbers that you will need. Billy Klein, please come to the podium. And then Alyssa Sosun, have a seat by the door. Please say your name and your date of birth.
Billy Jesse Klein, 3165.
Thank you, sir. You're here today on two matters. The first one is a failing to go to your pretrial conference, and that was in April of 2018. So you already have an attorney in that case. Your next hearing is March 11th at 8:30 in the morning, and you have a $3,600 bond on that matter. You do have release conditions that are the same as they were before. Your other matter, though, is a grand jury warrant. And the grand jury warrant is alleging that in November of 2022, and then again in April of 2024, the following may have been committed. 1 count conspiracy, which is a Class 2 felony. 1 count dangerous drugs for sale, which is a Class 2 felony. 2 counts narcotic drugs for sale, which is a Class 2 felony. 1 count illegally conducting an enterprise, which is a Class 3 felony. And 1 count money laundering, which is a Class 3 felony. The grand jury found probable cause and issued a warrant for your arrest. This court is appointing an attorney to assist you. Your next hearing will be downtown Phoenix on March 11th at 8:30 in the morning on your grand jury matter. So because you were out on felony release on that 2018 matter when these new allegations may have occurred, you are not eligible for release today. So don't pay the bond that's on the other one. You'll get 2 sets of paperwork. You will be in custody until March 11th. And then in the afternoon on March 11th, you also have a bail eligibility hearing that afternoon at 1:30, and they can determine if you may be released at that time. Please take your paperwork, sir. Alyssa Sosun, please come to the podium. Steve Flores, have a seat by the door. Please say your name and date of birth.
Alyssa Shelton, 8/20/90.
Thank you, ma'am. You're here today on a probation violation warrant. It is alleged that you violated terms 1 and 15, and also that the GPS was removed on or about August 23rd of 2025. So an attorney has been appointed to assist you. Your next hearing will be downtown Phoenix on March 11th at 8:30 in the morning. Under Arizona Criminal Rule 7.2C, you are not eligible for release today, and you will be held in custody until your probation hearing. At that time, the judge may change these orders. Please take your paper.
Do you know who the attorney is that's appointed?
It is going to be the public defender, and their phone number is on your paperwork.
Thank you.
Steve Flores, please come to the podium. Christopher Gray, have a seat by the door. Please say your name and date of birth.
Steve Flores, 4888.
Thank you, sir. You're here today because you failed to go to your final trial management conference, and that was on September 9th of 2022. You already have an attorney in your case. Your next hearing will be March 10th at 8:30 in the morning. You are eligible for release, but it is under a cash-only appearance bond of $500,000. If you're able to post that bond, make sure you go to your hearing and follow your release conditions carefully. They're the same as they were before. If you are not able to post the bond, you'll stay in custody and be transported to your hearing on March 10th. Please take your paperwork. Christopher Gray, please come to the podium, and then Lonzie Lee, have a seat by the door. Please say your name and date of birth.
Christopher Gray, 1887.
Thank you, sir. You're here today on 3 matters. It appears that you have a new case and 2 probation violation warrants. So in your new case, it was alleged you committed theft of means of transportation, which is a Class 3 felony. An attorney has been appointed to assist you. Your next hearing in your new case is in March 19th at 8:30 in the morning. So on your new case, there is no bond set, but you do have bond in your probation cases. So on your probation violations, there was warrants out for you alleging that you had violated terms 3, 5, and 7, and that you failed to self-surrender on December 1st. So a warrant was issued for your arrest. An attorney has been appointed to assist you, and your next hearing is March 11th at 8:30 in the morning, so that is much sooner. These warrants each carried a bond. One of them was $150, the other one is $750. So together that is $900 secured appearance bond. If you're able to post your bond, make sure you follow your normal terms and conditions of probation, call your probation officer, and go to your hearing on March 11th. And then you also need to go to your hearing later in March for the new case. If you're not able to post your bond, you'll stay in custody until your probation case hearing, and then at that time the judge may change these orders. If they don't, make sure you alert them that you do have that new case coming up and you'll have all the information for it. It is on your paperwork. All right, please take your paperwork, sir. Lonzie Lee, please come to the podium. Justin McBurney, have a seat by the door. Please say your name and date of birth.
Lonzie Love, last name Lee, 6/20/86.
Thank you, sir. You're here today because you failed to go to your initial pretrial conference on December 9th of last year. You already have an attorney in your case, and now you have a new hearing date on March 11th at 8:30 in the morning. You're still eligible for release. It is with a cash-only bond of $100. If you're able to post that, you have the same release conditions as before. If you're not able to post it, you will stay in custody and be transported to your hearing. Please take your paperwork, sir. Justin McBurney, please come to the podium, and then Juan Perez Diaz, have a seat by the door.
Hello.
Please say your name and date of birth.
Justin McBurney, 11/05/2003.
Thank you, sir. You're here today on a new case alleging that you were trafficking stolen property. That's a Class 2 felony. Also, 2 counts of organized retail theft, which is a Class 4 felony. This court did find probable cause and appointed an attorney to assist you. Your next hearing will be downtown Phoenix on March 19th at 8:30 in the morning. So you are going to be released today under your supervision of your probation officer. You do have 2 probation cases going on as well, and on both of those, an attorney has been appointed to assist you. You have a Term 1 violation in each of those probation cases now. Your hearing will be March 11th at 8:30 in the morning, and again, you are going to be released on your promise to go to your hearings and follow the terms and conditions of your probation. For your matter, sir, though, I did look and I saw that you had just been in trouble in Mesa for almost the exact same thing, and that it really cost you dearly as far as the consequences are happening to you now.
Yes.
So even though you're being released under your probation officer's supervision, really take to heart about how you can get this worked out and that you will comply with your conditions of probation so you can make it through that. Okay?
All right, thank you.
All right, please take your paperwork. Juan Perez Diaz, please come to the podium. Winton Ashley, have a seat by the door. Please say your name and date of birth.
Juan Carlos Perez Diaz, January 1st, 1996.
Thank you, sir. You're here today because you failed to go to your sentencing on October 28th of 2025. But I do see that you self-surrendered and that you are trying to take care of this warrant. I also see that, this has been going on for a while. So you have an attorney in your case already that was appointed and working with you. Your next hearing is March 10th at 8:30 in the morning, downtown Phoenix. You are going to be released on your promise to go to that hearing with the same release conditions as before. So you're not going to be held in custody, but make sure you go to that hearing or they will issue a warrant for you with bond.
March 10th?
March 10th.
Sir, thank you.
Please take your paperwork, sir. Winton Ashley, please come to the podium. Erica Hernandez, have a seat by the door. Please say your name and your date of birth.
Winton Ashley, August 4th, 1989.
Thank you, sir. You're here today on a probation violation warrant. It is alleged that you violated terms 4 and 15. I looked through your warrant and I also looked through your APETS notes. And I noticed that the warrant was issued prior to you reporting in that you had been engaging in the substance abuse treatment. Also, the APETS note said that you were working with your field probation officer to quash this exact warrant, but no motions have been filed yet. So the warrant is still outstanding. So an attorney has been appointed to assist you in this matter. Your next hearing will be downtown Phoenix on March 11th at 8:30 in the morning. You are going to be released today under the supervision of your probation officer, so no bond is required. Just make sure you go in and keep up the good work of trying to get that treatment that you've been working on.
Yes, ma'am.
Okay.
I just got approved for a flex care, COP.
Oh, good.
Transitional living placement.
Well, I hope that works out for you, sir.
Thank you.
Okay.
I have an appointment at 2 o'clock this morning.
Well, you should be out before then. Okay, and there is, this one should not be this way. I had changed this. Okay, my changes didn't stick. Number 20 will need to be reprinted because I had changed this. Copy. Yeah, just 20. All the other ones, it seemed to have stuck, my notes and everything, but just 20 didn't. All the other ones are okay. Yeah. Okay, I'm glad I saw that. All right. Miss Erica Hernandez, please come to the podium, and then after that will be Richard McKee. Please say your name and your date of birth.
Erica Hernandez, August 24th, 1987.
Thank you, ma'am. You're here today on several matters. It's actually 5 matters total. So the first one is an arrest warrant, and the arrest warrant is from allegations of, excuse me, is that the first one? Yeah. The first one is an arrest warrant from February 10th of 2025. So it is alleging that you took the identity of another, and that's a Class 4 felony, and then fraudulent use of a credit card. So the state has brought charges against you. This court is appointing an attorney to assist you. Your next hearing will be March 19th at 8:30 in the morning, downtown Phoenix. You are going to be released to be supervised by your assigned probation officer. And the reason that's happening is because in your APETS progress notes, it is noted that you have steady employment, stable housing, that you do your UAs as required, and that you have been working with FinCom to work out your payments. And that is noted, and that is why you're going to be released under the supervision of your probation officer. So your other 4 cases They are all Term 1 violations because you have 4 probation cases. So you'll have an attorney in each of those, and your next hearing is downtown Phoenix, March 11th, and that's at 8:30 in the morning. And again, all of them, you're going to be released under the supervision of your probation officer.
Okay.
So you should get 5 sets of paperwork total. You do have 2 court hearings. Make sure you go to both. And make sure you call your probation officer once you're released in a few hours today.
Okay.
All right. Please take
Thank
your
you.
paperwork. Richard McKee, please come to the podium. And then after that will be Pedro Lopez Hernandez.
How you doing today?
Hello. Please say your name and date of birth.
Richard McKee, April 6, 1989.
Thank you, sir. So yours is a little different. We are going to have a small discussion. Before court, you were handed a placard to read. Were you able to review that?
Yes.
Okay. So now you have a decision to make. And I'll explain the decision briefly, and then you can make your choice. So what you have is a warrant from the state of Indiana. They are asking for you to come back. You can demand a civil extradition hearing that is a civil hearing, so you would hire your own attorney to represent you. And at that hearing, they would decide if a governor's warrant should be issued for your extradition. And in order for that governor's warrant to be in effect, both the governors of Arizona and Indiana would have up to 90 days to sign it. I would set that hearing for March 16th at 1:30 in the afternoon. And because the warrant here is saying that no bond is allowed, but that's not allowed under the Arizona laws, you would have bond set at $50,000 cash. So you can demand that. Or you can waive your extradition hearing, and if you waive it, you would be held in Maricopa County custody for up to 30 days. The sheriff's office would notify Indiana that you're ready to be picked up, and they would have that time to come and pick you up. And that 30 days would begin tomorrow. If they don't come and pick you up, you would be released from custody. So you can demand your hearing, or you can waive your hearing.
I'm aware of my hearing.
Okay, I have to ask you some questions then. Did you read the waiver of extradition paperwork?
Yes.
Do you understand you do not have to sign the paperwork?
Yes.
Do you understand you have the right to a hearing?
Yes.
Do you understand you have the right to hire a lawyer at your own expense?
Yes.
Do you understand you have the right to demand that the governors of Indiana and Arizona sign the warrant before you are returned?
Yes.
Do you understand you have the right to bail? In this case, it would be $50,000.
Yes.
Do you want to give up those rights and sign the paperwork?
When you say $50,000 is cash, it is not no reduction like 10% or nothing. It's just 50,000 straight here.
Okay. Has anyone threatened you or promised you anything to get you to sign the paperwork?
No.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No.
Okay. All right. So in that case, I find that you knowingly, intelligently, and voluntarily are signing the waiver, and I will also sign it. I will direct the sheriff's office to notify Indiana that you are ready to return. Indiana will have 30 days from tomorrow to pick you up unless there are any local Arizona charges pending. Okay. If there are local charges pending, they would not start 30 days until the conclusion of that case. That's why I just want to double check. Okay. Do you have any questions?
Not at all.
Okay. Please step over here. Okay. And while he's signing that, I will read in our one house call who is being combative. That is Wendy Waltford, date of birth 8/21/1980, here on a new justice court case for assault and resisting arrest, which are both misdemeanors. She does not have an attorney appointed. She can hire her own. Her next hearing is at the Ironwood Justice Court on March 9th at 8:30 in the morning, and she does have a $500 secured appearance bond. She does have conditions of her release that include not to return to the Dollar General in Buckeye, Arizona. I will explain this to her. It is not my intention to return to the recording, so if there are any changes, they will be reflected on the written order. Okay, thank you. All right, you'll have your paperwork, and then the time will start tomorrow.
Tomorrow. So they got by April 4th to come get me?
Today is the 4th? Yes.
Oh, so.
So tomorrow's the 5th. Mhm.
Process. Changing.
Good morning. Is there now a Spanish language translator on the line?
Good morning, Commissioner. This is Roberto, ID 8428, Flying Bridge Spanish interpreter, ready for your instructions.
Thank you. Mr. Roberto, I first need to ask you if you will swear or affirm that you will directly translate my words from English to Spanish and the defendant's words from Spanish to English exactly as we say them or to the best of your ability.
I do swear.
Thank you. We'll begin. Mr. Pedro Lopez Hernandez, please come to the podium.
Señor Pedro López Hernández, por favor acérquese al podio.
Okay. This is a criminal hearing, so you do have the right to remain silent.
Gracias. Esta es una audiencia criminal, por lo cual usted tiene el derecho de permanecer en silencio.
Anything you say or do may be held against you.
Cualquier cosa que usted diga o haga puede ser utilizada en contra de usted.
This hearing is being recorded as well as broadcast live.
Esta audiencia está siendo grabada y se está transmitiendo en vivo.
Please wait until the translator finishes speaking before you speak.
Por favor, espere hasta que el intérprete termine de hablar antes de usted hablar.
Please say your name and your date of birth.
Por favor, dé su nombre completo.
Pedro López Hernández, 7 de enero del 76.
Pedro López Hernández, January 7, 76.
Thank you. You are here today on two matters.
Gracias. Usted se encuentra hoy aquí bajo dos asuntos.
The first one is a new municipal court case.
El primero es un nuevo caso de corte municipal.
It is alleging that you were driving without a valid license.
Se alega que usted estaba conduciendo sin una licencia de conducir válida.
Because it's alleged as a misdemeanor, this court cannot appoint an attorney for you, but you can hire your own attorney.
Debido a que esto es un caso menor, la corte no puede asignarle un abogado, pero usted puede contratar un abogado para usted.
Your next hearing is at Buckeye Municipal Court on March 24th at 2 in the afternoon.
Gracias. La siguiente audiencia sería en la Corte Municipal de Buckeye, marzo 24 a las 2 de la tarde.
Your second case is a new Superior Court case.
Su segundo caso es un caso nuevo del juzgado superior.
On this one, it's alleged that you were shoplifting, which is a Class 6 felony.
Gracias. En esta se alega de que usted estaba robando, que es un delito clase 6.
An attorney has been appointed to assist you in this case.
Gracias. En este caso se le ha asignado un abogado para que pueda asistirlo.
Your next hearing in this case is downtown Phoenix on March 19th at 8:30 in the morning.
This is the interpreter. My apologies, when I couldn't hear that date and time clearly. Would you be so kind to repeat?
Yes. It is downtown Phoenix on March 19th at 8:30 in the morning.
Gracias. La siguiente audiencia se daría en la Corte Juzgado de Phoenix Centro o Downtown en marzo 19 a las 8:30 de la mañana, AM.
On both of these cases, you are going to be released on your promise to go to the hearing.
En ambos casos, o para estos ambos casos, se le va a dar la libertad bajo la promesa de que usted va a asistir a las audiencias.
Also, you may not return to the scene of the alleged crime.
Además, usted no puede regresar a la escena del supuesto crimen.
While your cases are pending, you are not to go to any Lowe's stores in Arizona.
Gracias. Mientras su caso se encuentre pendiente, usted no podría ir a ninguna tienda Lowe's en el área de Arizona.
All of this information is written on your paperwork, including your attorney's phone number.
Toda esa información estaría en los documentos que se le van a entregar, incluyendo el nombre y número de su abogado.
Okay. Please take your paperwork, sir.
Thank you.
Por favor, tome los documentos.
Mr. Roberto, thank you very much for your service to the court. That was our only Spanish language defendant. Okay, thank you. That was our last defendant for this calendar, so the 5 a.m. initial appearance hearing calendar is now in recess until 8 a.m.
Goodbye.
It is for one count of criminal damage, a Class 1 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have an arraignment hearing in the White Tank Justice Court on March 24th at 9:30 in the morning. I am going to release you today on your own recognizance. That is your promise to appear at this hearing. And you do have written conditions of release. I also caution you to read these conditions very carefully because you do have an alleged victim in this case. You may not have any uninvited contact with the alleged victim. So if the alleged victim does not consent to contact, then you may not do so. And if you live with the alleged victim and they do not consent, then you will have to find an alternative residence. You may contact law enforcement for one civil standby to collect any of your belongings. This will be in your paperwork, ma'am. Did you have any questions?
Pues, él hizo esas acusaciones para mí.
So he made those accusations against me?
So it appears as though the police were called due to an incident that took place at your home. And because it was a domestic violence incident and there were allegations that a phone was broken, the police arrested you on that charge and have charged you with criminal damage. Anything further, ma'am?
That would be all.
If you will take a step to your left, the officer will get you that paperwork. Thank you, ma'am. And interpreter, do you mind asking the gallery if there is anybody else that will need your services before you disconnect?
Of course. ¿Hay alguien más que esté presente que necesite un intérprete en español?
Nobody has indicated they do. I appreciate your services this morning. Feel free to disconnect at your convenience.
Thank you, Your Honor.
Thank you. If I could have Jaime Rodriguez to the podium and Michael Russell to the chair. May I get your name and date of birth?
Jamie Rodriguez, October 13th, 1981.
And can I get counsel for Mr. Rodriguez to state their appearance?
Yes, Your Honor. Good morning. Adam Susser from the Weingart firm, making I believe, a limited notice of appearance for today's IA on these charges.
Thank you, Mr. Susser. And the state?
Thank you, Your Honor. Brooke Hahn of House and State.
Thank you, Ms. Font. It does look like we are here today on a new case. It is for 4 counts of stalking, a Class 5 felony, and 4 counts of endangerment, a Class 6 felony. It does have a range of dates beginning January 25th, 2026 through February 14th of 2026. I am going to hear from both counsels. However, before I do that, I wanted to give an overview of what I have reviewed in this case and then see if I can get an update from there. It's my impression that it appears Mr. Rodriguez was previously arrested for these charges on February 16th of 2026. He was released to pretrial services with electronic monitoring. After that, a direct complaint was filed by the state. However, it only included 2 charges at the time, rather than the multitude of charges that were listed on the pre-filing. And then it appears as though he was arrested again on March 3rd, 2026 for these same charges. However, when I review it, it appears only one of the charges listed on today's pre-filing has already been included in the direct complaint that was previously filed. And I note that is the stalking charge from February 14th of 2026. So, Ms. Gaunt, I'll start with you. Is that an accurate representation so far of what's going on?
I believe so, Your Honor. I think his original arrest from mid-February, criminal damage was the majority of the offenses that he was pre-booked on at that time. And I think that at this point, law enforcement has more, with more detail laid out the stalking and endangerment charges.
Thank you, Ms. Gaunt. And Mr. Susser, do you agree that with what I've said so far, that it appears one charge has he's been charged with, and everything else is duplicative of what he was brought in on February 16th for the pre-filing.
It sounded pretty accurate to me, Your Honor, and just as a side note, I applaud the court's preparation for the IA. But that said, my understanding in looking at the Form 4 from this case and the Form 4 from the previous case, I didn't exactly do a side-by-side comparison, but what it looked like to me is that after they arrested and booked him on the previous 12 counts originally, the cops involved went out and did a follow-up interview with one other individual, and it was something as simple as, oh yeah, I was also present for those offenses. So what the detective did was book him again with the sole intention of kind of adding one victim to what was already previously arrested for charges. I didn't see any new conduct in the current arrest. All I saw was new victim. That said, I have a lot that I could say about what I'd like for release conditions, but I don't want to take the court's time unnecessarily if Your Honor is already inclined in light of that background to do something that I'm contemplating.
Thank you, Mr. Susser. So I'll tell you what the court is inclined to do, and then I will give you guys an opportunity to make arguments. I'm inclined to find probable cause for everything except for the one stalking charge from February 14th of 2026 that's already pending in the current CR 2026. And then I'm inclined to just release him on pretrial services with electronic monitoring. That was previously done on February 16th. It doesn't appear any additional information as it relates to violation of his previous release conditions have been violated. So I'm inclined to just kind of keep with what was previously done on February 16th, set some hearing dates as it relates to these new charges. I do show that you have hearings coming up on the already filed case in April, may or may not be combined if charges get filed on this case. So that's my inclination. Ms. Gaunt, did you have anything different that you would like for the court to hear?
Yes, Your Honor. Unfortunately, I'm not sure. My guess is that my office made a recommendation on February 14th, although I haven't looked at it to review it today. But the state is asking for a $25,000 secured appearance bond along with electronic monitoring. I certainly can understand the court's reasoning in relying on the other on the previous release conditions, given that it doesn't appear that there is new conduct. However, the state is concerned, given that there are multiple offense dates, that these are domestic violence offenses. We believe that there is a strong weight of the evidence against Mr. Rodriguez, given the surveillance and the GPS tracker that law enforcement had installed on his vehicle. And again, the victim indicates in the Form 4 that she is in fear for her life because of Mr. Rodriguez's alleged behaviors. And so given all of that, we do think that a bond is necessary. Thank you.
Thank you, Ms. Gaunt. And Mr. Susser, was there anything you wanted to provide or any response to Ms. Gaunt?
Well, with absolutely no reflection on Ms. Gaunt herself, I'm going to find it pretty ironic that the state's requesting such a heavy bond when they already made me a Class 6 open plea offer in the existing case on all of the existing charges with a stipulation to probation and no jail time. So I would put it to the court this way. At worst, I would ask the court to do what it was already inclined to do, which is simply extend the already determined release conditions to these new charges. But that said, that the 30-second spiel I'll make, Judge, is much like the previous incident. I highly suspect that this was a detective gone rogue without consultation of the actual charging attorney, because much like last time when they submitted on 12 counts, the state only charged 2. I suspect we're going to see something very similar if the state even elects to file new charges at all. All of that said, rather than sort of reissue a new release order with a pre-file number and risk confusing pretrial services on the point, I'd ask the court just to release him on his own recognizance. He's already on an electronic monitor. It's noteworthy. I mean, he's only been on release for 2.5 weeks, but no violations, no curfew issues. His pretrial services officer, and it's telling, at both his original arrest and this one, the PSA report recommended PSA release, no electronic monitoring at all, let alone a bond or a bracelet. So I think the simpler, cleaner thing to do is just release him OR, but at the same time, I understand if the court's inclination is just to extend the already determined release conditions, but I would say certainly no worse.
Thank you, counsel. So after my review of everything and hearing from both counsel from the state as well as your counsel, sir, what I'm going to do is I am going to appoint an attorney to represent you today, because as Mr. Susser had indicated, at this time for this new pre-filing, he is just entering an appearance, a limited appearance for purposes of today. Of course, if this does move forward and you choose to hire him, he can file an entry of appearance, but I am going to appoint an attorney to represent you if that does not happen. I am going to set a status conference on March 19th at 8:30. and a preliminary hearing on March 23rd at 8:30. For purposes of probable cause, I'm going to find probable cause on all counts except for that one stalking charge on February 14th, as that is already a pending charge on the CR 2026 case. And I am just going to mirror the release conditions of the current case that you have, which means you will be released to pretrial services with electronic monitoring. I have noted in here this is in conjunction with the current case. Same release conditions, you're not to return to the scene of any alleged crime, no contact with any alleged victim, and you may not possess any weapons. Again, it should mirror the other release conditions you previously did receive. I do believe that concludes everything. Mr. Susser, did you have anything else for the court?
Just a question, Your Honor, real quick. I'll waive any necessary Rule 5 time just to avoid an extra unnecessary visit to EDC. Does it make more sense to line up his status conference on these charges with the one that's already set in the other case?
Mr. Susser, it totally does make sense. They're not going to allow me to modify these dates that I'm given here in IEA. Of course, if you do get hired, feel free to ask to consolidate those, but unfortunately, they're not going to allow me to do that here today.
Understood.
Thank you, Mr. Susser. Ms. Gaunt?
I have nothing further, Your Honor.
Thank you. This does conclude our hearing, Mr. Rodriguez. If you'll take a seat in the gallery, they'll bring you that paperwork, and Mr. Susser, I'll have them email you a copy.
That's perfectly fine. Thank you, Your Honor.
Thank you, and feel free to disconnect.
Thank you, Your Honor.
And Ms. Gaunt, are you going to come back later at the end of the calendar?
Would that be okay?
That's perfect. Thank you, Ms. Gaunt. And then do you mind sending an email copy of the release conditions to Mr. Susser? Yeah. Thank you. All right, can I have Michael Russell to the podium and Mariah Butterfield to the chair? May I get your name and date of birth?
Michael Wayne Russell, 9/23/1980.
Thank you, sir. You are here today on a probation violation warrant that was issued for you. I'm going to appoint an attorney to represent you and set a probation revocation hearing March 11th at 8:30. In this case, you are being held non-bondable, so you will remain in custody until at least that hearing on March 11th. This will be in your paperwork, sir. Did you have any questions?
No, it's pretty much straightforward. I was just released from BOP custody, and over here, that's the only reason why this is a violation. So.
Okay, so you were just released from federal prison and they transported you here?
Yes.
All right. Thank you, sir. If you'll step to your left, the officer will get you that paperwork. Mariah Butterfield to the podium. Hernando Cruz Hernandez to the chair. May I get your name and date of birth?
Mariah Butterfield, June 19th, 1991.
Thank you, ma'am. You're here today on two cases. You're here on a new case as well as your probation case. Your new charge is for one count of shoplifting, removal of goods, a Class 4 felony, and one count of narcotic drug possession, a Class 4 felony. And then because you were on probation at the time of this alleged offense, you're here on a Term 1 violation. For purposes of today, I'm not finding probable cause for the narcotic drug charge. It does not mean it's dismissed. They may test that substance and move forward. I am finding probable cause for the shoplifting charge and the Term 1 probation violation. I'm appointing an attorney to represent you in both of these cases, and I'm going to give you a few hearings. You are going to have a status conference March 10th at 8:30, a probation revocation hearing, March 11th at 8:30, and a preliminary hearing, March 12th at 8:30. So you have 3 hearings coming up 3 days in a row. On your new charges, you have a secured appearance bond of $1,500. However, on your probation case, you are being held non-bondable. So posting that $1,500 would not get you released until you at least have your probation hearing on March 11th at 8:30. This will be in your paperwork, ma'am. Did you have any questions?
No.
Okay, go step to your left. The officer will get you that paperwork.
Thank you.
Mr. Cruz Hernandez to the podium. Stephen Olson to the chair. May I get your name and date of birth?
Arnaldo Cruz Hernandez. I'm born December 1st, 2000.
Thank you, sir. You are here today on a new case. It is for 1 count of aggravated assault, a Class 3 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference, March 10th at 8:30, a preliminary hearing, March 12th at 8:30.
I need to come back?
So you have 2 hearings that are going to come up. You have a secured appearance bond in the amount of $50,000. In the event you post that bond and are released from custody, you have written conditions. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. If you do post bond, it's going to be your responsibility to make sure you attend those hearings on March 10th and March 12th and any future hearing dates that you're given. If you fail to appear at any of those hearings, a warrant would issue for your arrest and you would lose the bond that you posted. This will all be in your paperwork, sir. Did you have any questions?
Spanish. I don't listen everything, so
Are you indicating you need an interpreter?
I need a translate because I'm not listening like really clear.
Okay, please take a seat in the gallery and we'll call an interpreter.
Okay.
Okay, thank you. Stephen Olson to the podium. Rolando Yazzie to the chair. May I get your name and date of birth?
Stephen Olson, 8586.
Thank you, sir. You are here today on a new case. It is for 1 count of aggravated taking the ID of another, a Class 3 felony. 1 count of possession of a weapon by a prohibited person, a Class 4 felony. 1 count of dangerous drug possession, a Class 4 felony. 1 count of theft, a Class 6 felony. And 1 count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I am appointing an attorney to represent you.
Okay.
You're going to have a status conference March 10th at 8:30 and a preliminary hearing March 12th at 8:30.
Okay.
In that case, you have a secured appearance bond in the amount of $40,000. In the event you post that bond and are released from custody, you do have written conditions. You may not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness. This will all be in your paperwork, sir. Did you have any questions?
You say secured bond, I could put up collateral?
Secured meaning you can use the bail bonding company. Bail bonding companies typically require 10% plus collateral.
Okay.
All right. If you'll step to your left, the officer will get you that paperwork. Thank you, sir. Rolando Yazzie to the podium and Alonzo Walker to the chair. May I get your name and date of birth?
Rolando Yazzie, 41295.
Thank you, sir. You are here today on a warrant from the Yavapai County Superior Court alleging that you violated probation. I'm appointing an attorney to represent you and setting a hearing in Yavapai County on March 9th at 8:30. You do have a secured appearance bond in the amount of $25,000. In the event you post that bond and are released from custody, you do have written conditions. You're not to possess weapons or alcohol, and you must contact your probation officer within 72 hours. You also will need to ensure that you get yourself to that hearing. It is in Yavapai County on March 9th. If you fail to appear, a warrant would issue and you would lose the bond. If you don't post bond, then you will remain in custody and they will transport you to that hearing. Did you have any questions?
No.
Please take a step to your left and the officer will get you that paperwork. Alonzo Walker to the podium. Luis Gonzalez to the chair. May I get your name and date of birth?
Alonzo Walker, 51086.
Thank you, sir. You are here today on 2 probation violations with allegations you violated terms 3 and 15 of your probation. I'll appoint an attorney and set a probation revocation hearing March 11th at 8:30. You have a secured appearance bond of $500 in one case, $250 in the other. for a total bond of $750. In the event you do post that bond and are released from custody, you have written conditions. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours. This will be in your paperwork, sir. Did you have any questions? Please take a step to your left, and the officer will get you that paperwork. Luis Gonzalez to the podium. Mr. Sines to the chair. We have Luis Gonzalez.
Hi, come to the court, man.
He's dressed out.
Luis Gonzalez?
Yeah. Yes. Thank you. I'm sorry?
He's coming.
Wonderful. And then we do have the interpreter on the line, so if you don't mind giving the headphones.
No problem.
Thank you. And Mr. Interpreter, I am going to handle one more matter, and then I will call the case you appeared here for. And thank you for joining us again. May I get your name and date of birth?
Luis Gonzalez, 46-1990.
Thank you, sir. You are here today on a probation violation warrant with allegations that you violated terms 1, 3, and 5. I'm appointing an attorney and setting a probation revocation hearing, March 11th at 8:30. You have a secured appearance bond in the amount of $250. Are you currently here on anything else?
No.
Okay. In the event you post bond and are released from custody, you have written conditions. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours.
He's also got...
Does he have a Phoenix hold?
Sorry. Yeah, everything's going on.
Okay, so it sounds like there's a warrant from the city of Phoenix as well, so you'll likely see a judge at about 10 a.m. or 4 p.m. today. So if they issue a bond on that case as well, then this would be in addition to that. You'd have to post both in order to be released, okay?
Okay, so I'll be going to jail today, or?
So you have a bond in this case of $250, and then you're going to see another judge. I don't know what that judge is going to do if you'll have a bond on that case, but if they do set a bond, you'd have to post both of them to be released, and if you don't post, then you would stay in custody, okay?
Okay.
All right, so step to your left, the officer will get you that paperwork.
Let's have a seat. We'll get you out here if you know.
And then can I have Mr. Cruz Hernandez to the podium, please?
Oh, good.
And may I get your name and date of birth?
My name and birthday?
Can you hear the interpreter?
Yeah, no, just now. Say.
Yes.
All right, can I get your name and date of birth?
Hernaldo Cruz Hernández, nací el 1 de diciembre del 2000.
Bernardo Cruz Hernandez. I was born December 1st of 2000.
You are here today on a new case. It is for one count of aggravated assault, a Class 3 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference, March 10th at 8:30, and a preliminary hearing March 12th at 8:30. You have a secured appearance bond in the amount of $50,000. In the event you post that bond and are released from custody, you do have written conditions. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. This will all be in your paperwork, sir. Did you have any questions?
Okay, tengo una pregunta. Y para yo se pagar los $50,000, ¿tendría que salir de aquí primero o cómo?
I'd have a question. To pay the $50,000, do I have to get out of here first, or how?
So you have to post the bond before you will be released. They will take you to processing here in a moment, and they will give you instructions on how to get that posted. They'll give you access to phones to call family or friends, or to call a bail bonding company to have them assist you with getting that posted. Anything further, sir?
No. Bueno, no voy a dar esa cantidad, pero todo bien.
No, well, it's a mix-up, but everything's okay.
Thank you, sir. If you will step to your left, the officer will get you that paperwork. All right, and I do appreciate you joining us again to handle that case. Feel free to disconnect.
Thank you, Your Honor.
Mr. Sines to the podium. Nadia Kroll to the chair. Can I get your name and date of birth?
Elliot Mundo Sines, September 23rd, 1981.
Thank you, sir. You're here today on a probation violation warrant with allegations that you violated terms 3, 4, 5, and 7. I'm appointing an attorney to represent you and setting a probation revocation hearing March 11th at 8:30. You do have a secured appearance bond in the amount of $100. In the event you post that bond and are released from custody, you have written conditions. You must not possess any weapons or alcohol, and you must contact your probation officer within 72 hours. This will be in your paperwork, sir. Did you have any questions?
No, ma'am.
Please take a step to your left, and the officer will get you that paperwork. Nadia Kroll to the podium. Ms. Vo to the chair. May I get your name and date of birth?
My name is Nadia Kroll. My date of birth is 07/31/2000.
Thank you, ma'am. It does look like you are here today on two cases. You're here on a new case as well as a warrant that was issued. So your new charges are for 1 count of carrying a deadly weapon and failing to admit a Class 1 misdemeanor. In that case, you're not entitled to court-appointed counsel. I am finding probable cause and setting a hearing in the Santan Justice Court on March 24th at 9 a.m. On your second case, that is a failure to appear bench warrant that was issued out of the Maricopa County Superior Court related to a pending drug charge. I am going to affirm the attorney previously appointed to represent you in this case, and I'm going to give you some hearings in the Superior Court. You're going to have a status conference March 19th at 8:30 and a preliminary hearing on March 23rd at 8:30. I am going to release you to the supervision of pretrial services. You do have written conditions of release. You're not to possess any drugs without a valid prescription. You may not drive a motor vehicle without a valid driver's license. You're also going to get an envelope with your paperwork. You need to contact pretrial services upon your release. They'll remind you of your hearings as it relates to the Superior Court case. For the case for your new charges, that is in the Justice Court, so you're just being released on your own recognizance. That's your promise to appear at that hearing, okay?
Okay.
This will all be in your paperwork, ma'am. Did you have any questions?
No. I did actually for the new charges that I got. I wasn't sure about because I wasn't sure if the first charge was like actually went through or not yet. Like, because if that would make me a felon or not yet, to where I would still be able to technically carry a firearm.
As of right now, I don't show that you've been convicted of any felonies.
So that means I would have been able to carry a firearm technically.
As long as there's not something else I'm unaware of, such as a domestic violence issue or an order of protection against you, then yes, there's nothing at this time showing that you're a prohibited possessor.
Okay, so then it was just for lying.
The charge is for not admitting when they asked if there was a weapon in the vehicle, okay?
Okay.
All right. We do need to reprint number 9. If you could please take a seat in the gallery, they'll bring you out that paperwork.
Okay.
You just take a seat right where you came from. Thank you, ma'am. Ms. Vo to the podium. Nicholas Ovitt to the chair.
Yeah. Yeah. No, I know.
Can I get your name and date of birth?
Hanwell 9381.
Thank you, ma'am. You are here today on a new case for 1 count of criminal damage, 1 count of disorderly conduct, and 1 count of assault. They're all Class 1 misdemeanors. Probable cause has been found. However, due to the nature of your charges, you're not entitled to court-appointed counsel. You're going to have an arraignment hearing in the Peoria Municipal Court on March 24th at 9 a.m. I am going to release you today on your own recognizance. That is your promise to appear at this hearing on March 24th.
So am I getting charged for it?
So at this time, the police have submitted charges for criminal damage, disorderly conduct, and assault. It'll be up to the prosecutor's office if they move forward with these charges, but you have to attend that hearing on March 24th at 9 a.m. You also have written conditions. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. If you live at the same location as the alleged victim, you do have to find an alternative residence, but you can contact law enforcement for one civil standby to collect your belongings. This will all be included in your paperwork. Did you have any questions?
So if he's my husband, I cannot talk to him?
Correct.
Until that day?
Until the court changes the orders. So if you go to hearing that day and the court changes your release conditions and includes communication, then you
so
may.
I do not talk to him?
Not at this time.
Okay.
Okay?
Thank you.
If you'll take a step to your left, the officer will get you that paperwork. Nicholas Ovitt to the podium. Alexis Oakman to the chair.
Good morning, Your Honor.
May I get your name and date of birth?
Nicholas Hobbit, October 14, 1992.
Thank you, sir. You are here today on 4 cases. You're here on a new case as well as 3 probation cases. Your new charges are for 2 counts of dangerous drug possession, a Class 4 felony, 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. And because you were on probation at the time of this alleged offense in 3 cases, you're here on 3 Term 1 probation violations. I am finding probable cause and appointing an attorney to represent you in both cases. You're going to have a probation revocation hearing March 11th at 8:30, a status conference March 19th at 8:30, and a preliminary hearing March 23rd at 8:30. I am going to release you today on your own recognizance subject to the supervision of the Adult Probation Department, but you do have written conditions of release. You're not to possess weapons, you're not to possess drugs without a valid prescription, and you must contact your probation officer within 72 hours. This will be in your paperwork, sir. Did you have any questions?
No, ma'am, thank you so very much.
Okay, so it's up to your left. The officer will get you that paperwork. Thank you, sir.
God bless you, thank you.
And then can we clear the courtroom for our remaining cases?
Okay.
Can you wait out there for 1 moment, ma'am?
Well, she's not done, she's gonna go next, so we're gonna clear it out anyway. Everybody. No. Carlos. Keith Chase.
Can you get this for the last 2?
Black shirt, Chase, well, no.
Okay. Still swap them? Okay, perfect. Thank you.
All right, follow him.
And then Joshua Yates to the chair. And let's see back there. Okay, Joshua Yates and Carmen Aspling could have stayed, but that's okay. We'll call them in just a moment. May I get your name and date of birth?
Alexis Oakman, 12/4/94.
Thank you, ma'am. It does look like you are here today on 2 cases. You're here on a new case as well as a probation violation warrant. Your new case is for 1 count of public sexual indecency, a Class 5 felony, and 1 count of public sexual indecency, a Class 1 misdemeanor. And then you're also here because you were on probation at the time of this alleged offense. You're here on a Term 1 violation. I am finding probable cause and appointing an attorney to represent you. You're going to have a status conference March 10th at 8:30, a probation revocation hearing March 11th at 8:30, and a preliminary hearing March 12th at 8:30. On your new case, you have a secured appearance bond of $2,500. On your probation case, it is $500 for a total bond of $3,000. In the event you do post bond and are released, you'll be released to the supervision of pretrial services and equipped with electronic monitoring. You also have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you must contact your probation officer within 72 hours. This will all be in your paperwork, ma'am. Did you have any questions? Please take a step to your left, and the officer will give you that paperwork.
you go. Have some. 1-8. Right in there. Your Honor, then when he's done, I'll get the other one.
Thank you, I appreciate it. May I get your name and date of birth?
Joshua Adam Yates, 4192.
Thank you, sir, and can I get the state's appearance for the record?
Thank you, Your Honor. Brooke Gahn on behalf of the state.
Thank you, Ms. Gaunt. It does look like we are here today on two cases. You're here on a new case as well as your probation case. Your new charges are for 2 counts of sexual exploitation of a minor, a Class 2 felony, 1 count of sex offender online identifier, a Class 4 felony, and 1 count of failing to register or confirm your ID as a sex offender, a Class 6 felony. And then because you were on probation at the time of this alleged offense, you're here on a Term 1 probation violation. I am finding probable cause on these charges and appointing an attorney to represent you. You're going to have 3 hearings coming up, 3 days in a row. You're going to have a status conference, March 10th at 8:30.
Okay.
A probation revocation hearing, March 11th at 8:30. And a preliminary hearing, March 12th at 8:30.
Okay.
Next, we need to discuss any bond and or release conditions you may have. But before I make my decision, I do want to hear from the state. Ms. Gaunt?
Thank you, Your Honor. In regards to the new case, the state is asking for a $75,000 cash-only bond, along with electronic monitoring as is required by statute, no contact with any minors, no internet use, and also no contact with his co-defendant. This is based on the serious nature of these charges. Obviously, in any case, it's concerning when someone is allegedly in possession of child sexual abuse material, but in this particular case, it's even more concerning given that he is on probation for the same criminal conduct at this time. It's our understanding that he is transient and doesn't have a stable place to live. Given all of that and the particular circumstances, and quite frankly, the heinous nature of the child sexual abuse material that's alleged in this case, we believe that that bond is necessary. In regards to the probation matter, the state's asking that pursuant to Rule 7.2C that he be held non-bondable, as we believe that there is a reasonable probability that he will potentially be revoked to prison or otherwise suffer some jail time in regards to the probation violation. Thank you.
Thank you, Ms. Gaunt. And Mr. Yates, I have reviewed the allegations in this case, and I do note that you currently are on probation for a similar offense. In addition to that, I note that you were released from the Department of Corrections in July of 2025. And based on that, I am going to adopt the state's recommendation. I am setting a cash bond in the amount of $75,000 in your new case. In the event you are released on that case, you would be equipped with electronic monitoring. However, I am holding you non-bondable on your probation case. So posting that bond of $75,000 at this time would not get you released from custody until you at least have that hearing in the probation court on March 11th at 8:30. And this will all be in your paperwork. Did you have any questions, Mr. Yates? Okay. Mr. Yates, we do need to reprint his paperwork. You can take a seat in the gallery. And I'll reprint it. You can reprint Carmen too.
Come on through, Miss.
Can I get your name and date of birth?
Carmen Yates, 11179.
And do you have an additional name that you go by?
My maiden name is Oswald.
Thank you, ma'am. And can I get the state's appearance?
Thank you, Your Honor. Brooke Gahn on behalf of the state.
Thank you, Ms. Gaunt. We are here today on a new case. It is for 2 counts of sexual exploitation of a minor, a Class 2 felony. Probable cause has been found, and I'm appointing an attorney to represent you.
Okay.
You're going to have a status conference March 10th at 8:30 and a preliminary hearing March 12th at 8:30.
Okay.
Next, we need to discuss any bond or release conditions you may have, but before I do that, I would like to hear from the state. Ms. Gaunt?
Thank you, Your Honor. The state's asking for a $50,000 cash-only bond, along with electronic monitoring, no contact with any minors, no internet use, and no contact with her co-defendant. These requests are based on the nature of the charges. It is our understanding it doesn't appear that Mrs. Yates has any prior felony convictions, although we do believe that she has at least 1 prior misdemeanor conviction. Again, she was allegedly in possession of child sexual abuse material, and according to the admissions she made to law enforcement, she in fact sent that material to her husband, knowing that he'd previously been convicted of that same criminal conduct. Our understanding is that she does not have a stable residence at this time. And again, given the heinous nature, in this case particularly, of the alleged child sexual abuse material, we are concerned that she's a danger to the community.
Thank you, Ms. Scott. I have reviewed everything in this case. I've also listened to what the state had to say. I do agree. I do believe that you are a danger to the community based on the allegations that are before you today, so I am adopting their recommendation. You have a cash bond in the amount of $50,000. In the event you post that bond, you will be released to the supervision of pretrial services and equipped with electronic monitoring. You also have written conditions of release. You may not have contact with any co-defendant. You may not have contact with any minors. You are prohibited from accessing the internet through any electronic means. You're also prohibited from having any weapons and any drugs without a valid prescription. This will all be in your paperwork, ma'am. Did you have a question?
Okay, what happens if I can't come up with the money?
If you're unable to post the bond, you will remain in custody and they'll transport you to those hearings.
Okay, and what about my service animal?
Do you have somebody you could call regarding your service animal, or was the animal with you at the time you were arrested?
It was.
And did the animal stay?
The animal did not go. They did not let me even say goodbye to my dog.
They may
and that
have.
was my seizure dog.
If you had an animal at the time of your arrest, they likely took the animal as well and placed them in a shelter.
We had it with a friend of ours, but we cannot keep them at that location.
So are you indicating when you were arrested, they did not take the dog to a shelter and you left the
dog? I left him at home.
Okay, so then you'll have to contact whoever has them in their care to find somebody else to care for them, take them to an animal shelter, or contact the animal hotline. But
okay, then my husband will have to do that.
Okay, then your husband can do that, but he is your co-defendant, so you're prohibited from contacting him, okay? So if
and we live together.
So you guys will not be able to reside together if you're both released from custody, okay?
Okay.
All right. If you'd like to step to your left, the officer will get you that paperwork. Thank you, ma'am.
May I be excused?
Yes, thank you, Ms. Mott. The remaining cases will proceed as house calls due to being a danger to self or others. Case number 6, Kristen Vanuelos, date of birth September 19th, 1988, is here on a new case for 1 count of aggravated assault, a Class 3 felony, 1 count of criminal damage, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent him. He is going to have a status conference March 10th at 8:30, a preliminary hearing March 12th at 8:30. He has a secured appearance bond in the amount of $25,000. In the event he posts bond and is released from custody, he has written conditions of release. He may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. This will all be included in his paperwork. Case number 7, Adam Muir, date of birth May 24, 2004, is here on a new case for 1 count of burglary, a Class 3 felony. Probable cause has been found, and I'm appointing an attorney to represent him. He has a status conference March 10th at 8:30, a preliminary hearing March 12th at 8:30. He has a secured appearance bond in the amount of $5,000. In the event he posts bond and is released from custody, he has written conditions. He may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. This will also be in his paperwork. Case number 15, Richard Shenan, date of birth December 19th, 1958, is here on a new case for 1 count of assault and 1 count of disorderly conduct, both Class 1 misdemeanors. I am finding probable cause and appointing an attorney. He will have an arraignment hearing in the Surprise Municipal Court on March 10th at 1:30. He has a secured appearance bond in the amount of $500. In the event he posts bond and is released from custody, he has written conditions. He may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. This will all be in his paperwork. Case number 26, Victoria Hannabass, date of birth December 23rd, 1988, is here on a failure to appear warrant for a pending dangerous drug and drug paraphernalia charge. I will affirm the attorney previously appointed and set a status conference March 10th at 8:30, preliminary hearing March 12th at 8:30. I'm affirming the secured appearance bond in the amount of $500. In the event she posts bond and is released from custody, she has written conditions. She may not return to the scene of the alleged crime, she may not possess weapons, and she may not possess any drugs without a valid prescription. Case number 1, 2, and 3 are for Alexis Lane, date of birth August 17th, 1993. Her first case is a new case. It is for 1 count of narcotic drug possession, a Class 4 felony, 1 count of dangerous drug possession, a Class 4 felony, and 1 count of tampering with physical evidence, a Class 5 felony. She's also here on a direct complaint that was filed. It has an offense date of September 30th of 2025 for one count of taking the identity of another, a Class 4 felony, one count of dangerous drug possession, a Class 4 felony, and one count of theft of a credit card, a Class 5 felony. Under new charges, I'm finding probable cause. I'm appointing an attorney to represent her in both of these cases. She's going to have a status conference March 10th at 8:30, a preliminary hearing March 12th at 8:30. She does have a third case on the calendar. This is a warrant from the Tolleson Municipal Court for failing to appear at a hearing related to a shoplifting charge. I'll appoint an attorney and set an arraignment hearing in the Tolleson Municipal Court on March 9th at 8:30. In each of these cases, she does have a bond. On her new charges, she has a bond of $200. On the new filing in Superior Court, she has a bond of $800. And on the failure to appear warrant, she has a $500 bond for a total bond of $1,500. In the event she does post bond and is released from custody, she does have written conditions of release. She may not possess any weapons, and she may not possess any drugs without a valid prescription. This will all be included in her paperwork. If anything changes after I meet with her, I will update the written record. This concludes our 8 a.m. calendar, and we will now stand in recess until 11 a.m.
Okay, thanks. All right, this is the 11 a.m. initial appearance calendar for March 4th, 2026. The court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the 1st of the month will also apply to these hearings. All right, before we begin, I am going to read the victim's rights advisement in the event there are any victims observing the proceedings either here at the jail or virtually. If you are the victim of a crime with a case pending before this court, you're advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, the right to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. We'll begin with Mr. Aguero Herrera. If you will please come all the way to the podium. Please come in now, Mr. Aguero. Here you go. All right. Good morning, sir. May I have your full name and your date of birth, please?
Lázaro Aramis Agüero Herrera, 14 de agosto del 65.
Lázaro Aramis Agüero Herrera, August 14, 1965.
Thank you. You have been arrested on the following allegations. Aggravated assault with a deadly weapon or dangerous instrument. That is a Class 3 felony. Criminal damage as a Class 5 felony. Endangerment, a Class 6 felony. And assault as a Class 1 misdemeanor. There is probable cause for all of those crimes, and I am appointing a lawyer to help you defend your case. Your next court date will be a status conference, March 10th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing is scheduled for March 12th at 8:30 in the same court, and that address in downtown Phoenix will be on your paperwork. Based on the serious allegations against you, The court sets bail in your case at $50,000. That is a secured bail amount, which means you can use the services of a bail bond company to possibly post bail for less than the full amount. If you deposit that money and are released physically from the jail while the case is pending, you will be on an electronic ankle monitor with permission only to work. At all other times, you will be on house arrest. You may have no contact with the alleged victim. You may not return to the scene of the alleged crime. You are not to possess any weapons, no drugs without a valid prescription, no alcohol, and you must obey the terms of any order of protection that may be served on you. Your complete orders are in writing. If you will please step to your left, the officer will give you a copy. It will have your court dates and everything else I just told you on it. Thank you.
Great.
All right, and if the interpreter could make a general call for us, please, that'd be great.
Yes, of course, Your Honor. ¿Alguien más en la sala necesita los servicios de interpretación judicial en español?
It looks like we have no hands. All right, thank you so much. Have a great day.
Thank you, Your Honor. The interpreter will be disconnecting. Thank you. Bye-bye.
Thank you. All right, Mr. Tarango, Deshaun Tarango, will you please come all the way to the podium? And after that, Martine Trujillo, you can go to the chair. Where's Mr. Tarango? Here he comes. And then Martine Trujillo, will you go to the chair just inside the door? You'll be after Mr. Tarango. All right. Hello, Mr. Tarango. Can I have your full name and your date of birth, please?
October 4, 2006, Deshaun William Stevens Tarango.
All right, and then the appearance of the state, please.
Thank you, Your Honor. Bert Gautam, half the state.
All right, thank you. Mr. Tarango, you are here on a warrant from the Globe Justice Court, which I believe is from Gila County. This warrant was issued January 2nd of this year out of the Globe Regional Justice Court, where it appears you've been charged with disorderly conduct with a weapon, and it's difficult. I just have an abbreviated hit. It looks like it's a bench warrant, which would be a failure to appear warrant, and there's some note in here about it being possession of that weapon with intent to promote a criminal street gang. All right, and it set a $50,000 cash bail. I'm going to give you a court date in Globe of March 9th, which is 5 days from now at 8:30 in the morning in the Globe Justice Court. Right now you're in Justice Court. If your case proceeds from there, it will go to the Globe Superior Court. All right, then before I set conditions of bail or release, the state, I know, was asked to appear on behalf of presumably the Gila County Attorney's Office. Please go ahead.
That's correct, Your Honor. They are asking
Mr. Tarango, I just need you to keep eyes front, okay? All right, go ahead.
that the court simply affirmed the $50,000 cash-only bond. They have been looking for Mr. Tarango, and obviously it is their belief that he has fled Gila County, and as the court has already referenced, this is a bench warrant for failure to appear.
All right, thank you. And Mr. Tarango, in general, this court takes seriously the felony bonds of other courts around the state, and presuming that they know what they want and they knew why they ordered it. And it does, I see that it is a bench warrant and it's a weapons charge. So I am going to affirm the bond that was set by the Gila County judge, and that is $50,000 cash only. You'd have to post that to be released. If you do, you need to be in the Globe Justice Court on March 9th at 8:30, or you will lose that bail money. You'll never get it back, and there'll be another warrant issued for your arrest. If you don't post bond, then the Gila County sheriffs have to arrange for your transport from Maricopa. Okay, everything is on your paperwork, and I think we have it ready for you. Maybe he's checking something there. If you'll step to that, the officer will give you that paperwork. Thank you. Is that it?
Yes.
Okay, please go ahead. Yes, thank you. All right. All right, Mr. Trujillo, you can go ahead and come in, and then Tyler Johnson, will you please go to the chair? You'll be after Mr. Trujillo. Good morning, sir. May I have your full name and your date of birth, please?
Martin Gavin Trujillo, September 12th, 2004.
All right, thank you. You're here on a new case. You were arrested for one allegation of armed robbery, a Class 2 felony, one allegation of aggravated assault with a deadly weapon or dangerous instrument, that is a Class 3 felony. Also, aggravated robbery, which is a Class 3 felony. Based on what the police have presented, there is probable cause for all three of those things, and I am appointing a lawyer to represent you. I'm sorry?
What does that mean? You said probable cause?
Probable cause means the police have provided sufficient information for the court to believe that to a level of probable cause, which you can talk to your lawyer about what that level is. It is not enough to convict, it is enough for probable cause. It is a lower standard that you did these things. That's what it means. And so your case is going to proceed forward. I'm going to give you a lawyer and court dates.
Thank you.
And so the lawyer will help you defend your case. If you go to trial, it is proof beyond a reasonable doubt. At this very early hearing, it is probable cause, which is a much lower standard of proof. The police have met allegations. So please talk to your lawyer about how all of that works. Okay.
All right.
So I am appointing a lawyer for you. Your status conference is going to be March 10th, which is 6 days from now at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be March 12th at 8:30 in the same court. The address is on your paperwork, and as well as the date. And your bond in this case is $50,000. It is secured. If you post it, be sure to comply with all of your release conditions. Don't go to the scene of the alleged crimes. And whether you are in or out of custody, no contact with the alleged victim, nor with Emmanuel Starr, who may or may not be a current co-defendant of yours, but he is the other person accused in this investigation. I don't know the status of his case, but no contact with Emmanuel Starr under any circumstances, whether he does or doesn't have a case going. The court orders that. Okay. No weapons, no drugs without a valid prescription. Everything you need to know is on your paperwork. You can work with a bail bondsman to possibly post bail for less than the full amount. You'll have to call them from the jail and ask them what they want in order to put up that bond for you. Okay. If you step to your left, he'll give you your paperwork.
All right,
thank you. Mr. Johnson, Tyler Johnson. And then Francisco Hernandez, we go to the chair. All right, Mr. Johnson, can I have your full name and your date of birth, please?
Tyler John Johnson, 9/18/1986.
Thank you. You're on a new case. You were arrested for allegations of possessing dangerous and narcotic drugs, both for purposes of sale. Those are Class 2 felonies. Drug paraphernalia possession and resisting arrest as Class 6 felonies. There is probable cause for all of those things, and I am appointing a lawyer to represent you. Your next two court dates will be a status conference March 10th at 8:30 in the morning and a preliminary hearing March 12th at 8:30 in the morning, both of those in the downtown Superior Court. Your bond in this case is $5,000. It is secured. If you post it, comply with all of your written conditions. Do not go to the scene of the alleged crimes. No weapons, no drugs. Oh, no, I think I didn't order that. I think you were the one, you were allegedly passed out in a car at an intersection. So I didn't order that. Just no weapons, no drugs, no alcohol. Don't drive without a valid driver's license. If you step to your left, they'll give you a copy of your paperwork.
When's my next court date?
It's the 10th, which is 6 days from now.
All right.
All right, thank you.
But did they get me for sales?
They did book you for sales, indeed. All right, you can talk to your lawyer about that. Thanks. Mr. Hernandez, Francisco Hernandez. And then Juan Vitello, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth?
Francisco Hernandez, 6/11/75.
All right, thank you, Mr. Hernandez. You're here on a new case. You were arrested for aggravated driving under the influence of alcohol with a suspended license. That's a Class 4 felony. And then DUI alleged all four of the possible ways as misdemeanors. First, while impaired to the slightest degree. Second, with a blood alcohol of 0.8 or more. Third, extreme DUI with a blood alcohol of 0.15 to 0.20. And then what is usually called super extreme DUI, which is blood alcohol of 0.20 or more. All four of those are Class 1 misdemeanors. The punishment can vary depending on what a person is convicted of. On the aggravated DUI, the mandatory minimum statutory punishment is 4 months in prison followed by probation. But in the misdemeanors, it's something up to 6 months depending on what you're convicted of. I am appointing a lawyer for you. The lawyer can go over all of that with you. Presumably you went over some of those things with the lawyer when you took an endangerment conviction for drunk driving in 2011. If you don't remember it, your lawyer will refresh your recollection. Your status conference will be March 10th at 8:30 in the morning, with the preliminary hearing March 12th at 8:30. Those will be in the downtown Superior Court. Your bond is $2,500. It is secured. If you post it, you will also be alcohol testing for pretrial services. You are ordered not to possess any weapons. You are a prohibited possessor. No drugs without a valid prescription. No alcohol. And absolutely no driving at any time for any reason. You appear to entirely lack the legal right to drive. So the police allege you are confused on that point. So I put it twice in your order. Once in all caps. Don't drive. People who commit this type of offense, especially under the circumstances alleged against you, generally make other people die with great frequency. It is unbelievably dangerous. So do not drive. Everything is on your paperwork. You step to your left, you get a copy of it. Mr. Vitella, Juan Vitella. And then Paula Ramos, please go to the chair. Paula Ramos, to the chair, please. Thank you. All right, Mr. Vitella, can I have your full name and date of birth?
Juan Junior Vitella, September 16, 1996.
All right, thank you. You're on a new case. You're arrested for shoplifting with at least two prior predicate convictions or using a device to facilitate it. Also third-degree burglary. Both of those are class 4 felonies. There is probable cause for them, and I am appointing a lawyer for you. Your status conference in this case will be March 10th at 8:30 in the morning in the downtown Superior Court. And I'm just checking one thing. Your preliminary hearing will be March 12th at 8:30 in the same court. All right. In this case, your bond is $2,500. It is secured. If you post it, you must comply with all of your written conditions, which include don't go to this Lowe's store nor any Lowe's store, no weapons, no drugs without a valid prescription. You have at least 5 prior felony convictions, so you are a prohibited possessor. Everything is on your paperwork. If you step to your left, I'll give you a copy. Ms. Ramos, Paula Ramos, and then Edilberto Carreño, will you please go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Paola Valencia Ramos, 8/21/1992.
Okay, thanks. You're here on a warrant for failing to appear at your final trial management conference in a case in which you've been charged with 2 counts of possessing dangerous drugs, 1 count of possessing narcotic drugs, and 1 count of possessing drug paraphernalia. The first 3 are class 4 felonies. The paraphernalia is a class 6 felony. And this warrant was issued December 18 of 2025, again, after you failed to appear at your final trial management conference. You're going to have a post-warrant status conference in front of the trial judge on March 11th, which is a week from now, March 11th at 8:30 in the morning in downtown Phoenix. That address is on your paperwork. I'm going to affirm the bond that the trial judge set for you, and that is $1,000 cash only. If you post it, comply with all of your conditions. Do not miss your court dates. That is a relatively low bond for failing to appear at this stage of the case. It's probably because, well, you've got 3 priors. None of them is a Prop 200 prior. None of them. So I'm guessing you got a prison offer. If you do this again, no, Ms. Ramos, you lose the bond money, and it only goes up. The bond amount goes up. I mean, Judge Lang could order considerably more than this. So if you want to be out of custody while the case is pending, if you post this bond, you have to appear. If you don't, eventually the warrant will find you, and the bond will be something you can't afford. Go ahead.
My public defender is supposed to put in the motion to squash the warrant. I'm not sure why he hasn't as of yet.
Well, that was December, ma'am. This is March 4th. So whatever happened, no, I don't see any motion to quash. I don't see any of that.
That's odd.
So
Okay.
talk to your lawyer about that, and and next time if you've got a court case and you think there was a motion to quash and you don't know, and 3 months go by, you should be reaching out to your lawyer. But it's not credible to think that you didn't know you had a warrant. When somebody has a final trial management conference, that means the next hearing after that is your trial.
Okay.
It's so late in the case that, and with your priors, that raises a strong presumption that you are dodging court. So you can talk to your lawyer about that. Don't know that Judge Lang would have granted a quash on a failure to appear at a final trial management conference. That is far more serious. than just early hearings. You miss a final trial management conference in front of your trial judge, you should expect a bond. And this is extremely low in my experience for this type of case. So if you'll step to your left, you get a copy of your paperwork. Mr. Carreño, Edoberto Carreño, and then Mr. Wright will go to the chair. 28, okay. Yeah, let me just move, I'll just move him to the bottom. All right, after Mr. Carreño is Misty Wright, please. All right, sir, can I have your full name and your date of birth, please?
Gilberto Carreño, 04/29/1990.
All right, thank you. You're here on a new case. You were arrested for assault and disorderly conduct, both Class 1 domestic violence misdemeanors, also resisting arrest passively, which is a Class 1 misdemeanor. Based on what the police presented, there is probable cause for these things. Your arraignment hearing will be in the Buckeye City Court. That's March 11th at 1 in the afternoon. That is 1 week from now in the Buckeye City Court. In this case, you have a $1,000 secured appearance bond and written release condition. You may not live where the alleged victim lives. You may not have any contact with her. You may not respond to any contact from her. You can do a civil standby with law enforcement, and then you have to find an alternative residence and bring proof to your next court date. You may not possess any weapons, no drugs without a valid prescription, no alcohol. If you're served with an order of protection, you have to comply with that as well. And I did appoint a lawyer for you. At this moment in time, it's for purposes of bond only. If the Buckeye City Court chooses to continue to give you counsel because the state is asking for jail time, they're not yet. What I'm saying, if the state asks for jail time, that's when the Buckeye judge may be willing to extend the appointment. Right now, I'm just appointing a lawyer to help you with the bond issue if you can't post it. Everything is on your paperwork. Your court date is next week. If you step to your left, you get a copy. Ms. Wright, Misty Wright, and then Brittany Speaks. We go to the chair. All right. After Ms. Wright will be Brittany Speaks. All right. Hi, ma'am. Can I have your full name and your date of birth?
Misty Wright, 11/20/86.
All right, thank you. You're here on a probation violation warrant. You're on probation for a Class 6 felony. There was a petition to revoke your probation filed on December 5th that alleges that you violated terms 3 and 5. You'll get a copy of that petition from your lawyer, and I am appointing a lawyer for you in probation. Your revocation, arraignment, and possible disposition hearing will be March 11th, which is 1 week from today at 8:30 in the morning in the downtown probation court. The address is on your paperwork. Your bond is $500. It is secured. If you post it, comply with all of your written conditions, and call your PO within 72 hours of release. You step to your left, he has your paperwork. Thank you. All right, Ms. Speaks. And then after that, Tyrone Elliott, will you please go to the chair? Hello, ma'am. May I have your full name and your date of birth?
Brittany Speaks, 7/22/91.
All right, thank you. You're here on a new case and a probation hold, or a probation warrant, sorry. In your new case, you were arrested for dangerous drug possession, a Class 4 felony, drug paraphernalia possession, a Class 6 felony, and criminal trespassing as a Class 3 misdemeanor. I am appointing a lawyer for you in this new case and in your probation case. You are on probation, and back on September 12th of last year, there was a petition to revoke your probation, filed a forced petition to revoke your probation. It alleges that you violated terms 3 and 5. You'll get a copy of that from your lawyer, and I am appointing a lawyer for you. You have slightly different court dates right now. Your first one is going to be in the downtown probation court. No, that's wrong. I apologize. The first one is going to be in your new case. It's a status conference March 10th at 8:30 in the morning with a preliminary hearing March 12th at 8:30. Then your court date in probation court is in between those right now. It's March 11th at 8:30. That's a revocation arraignment hearing. I'm going to affirm the bond in your probation case at $750 secured with written release conditions. In the new case, for purposes of this hearing only, I only found probable cause from the criminal trespassing, not the drugs today, because the police didn't provide enough information to support their allegation that it was illegal drugs. But those charges are not dismissed. I'm just ignoring them for purposes of release conditions. So you just have a $50 bond on the criminal trespass case. It also ensures that you will be transported for court. That makes your bond across the two cases $800 secured. If you bond out, be sure to comply with all of your written conditions and call your PL within 72 hours of release. The number is on your paperwork. If you step to your left, he'll give you that. Thank you. Mr. Elliott, and then Corday Green, will you please go to the chair? Good morning, sir. May I have your full name and your date of birth?
Tyrone Elliott, June 28, 1987.
All right, thank you. Mr. Elliott, you were arrested for allegations of disorderly conduct and assault, both Class 1 domestic violence misdemeanors. There is probable cause for those, and I'm not appointing a lawyer for you. You don't financially qualify. According to the Form 4, which is the paperwork the police fill out, you are active duty military, but pretrial said that you declined the interview. So I don't know. Are you active duty military?
I am active duty.
Okay, all right. Then I do not believe you financially qualify for a court-appointed lawyer. You can hire one at your own expense, or you can represent yourself. Your next court date will be an arraignment hearing March 11th. That's a week from today at 8:30 in the morning in the Goodyear City Court. The address will be on your paperwork based on what's been alleged against you. The court has significant concerns regarding victim safety, and so your bond is $500 secured. If you post it, you have to comply with all of your written conditions. You may not go to the scene of the alleged crimes, which in this case is a park. No contact with the alleged victim. You may not respond to contact from her. No weapons, no drugs, no alcohol. And you may not live where she lives. What you can do is a civil standby to collect belongings, but you may not go there on your own. You have to bring a Goodyear officer with you to do a civil standby. You arrange that on the non-emergency number. They'll send an officer to go with you while you collect some things. And just to make it very clear, absolutely no contact with her, whether you are in or out of custody. And so I was unable to tell, do you have children with this person?
I have 2 children with her, and I have my own daughter that I have custody of.
Okay, so this order does not apply to your children.
They're all my children.
The one that's not hers. What I'm saying is, no, it doesn't apply to any of the kids right now. But, and I have a note I'm going to include in here. I'll probably have you sit down so I can dig it up and pop it in here. This order does not apply to the children, but you may not violate it in order to see your children. That is zero excuse, and I always make very clear on the record to people, I do not give you permission to violate release conditions in a criminal case in order to see your children. If you can't figure out a way to do it without contacting her, then you will not see your children for a window of time. And so, one second, I want to just get this language out of here.
I'm sorry.
I just want to pull some language out of the, it's kind of a pain. The police didn't say that you had kids with them, so I wasn't sure. It was difficult to tell from that. Okay, one second. So I wanted, because people like to say, but I couldn't see my kids, but I had to. And so I want it in here very, very clear that you don't have permission to violate it for any reason. Okay.
That means to not see her, not to talk to her.
No social media, no third parties, no nothing. You do not have contact with her.
With her, not the kids.
Correct. It does not currently apply to your kids.
Okay.
The police didn't give any information regarding, the effect on the kids or any alleged danger to the children.
And so I have to find a place for me and my daughter because my daughter has...
Right, yeah. If you have a kid that's not this victim's at all, right, then that'd be one of the, it's not really a belonging, but you need to go on a civil standby with the officer and I say, I need to pick up my essential belongings. You get ID, you get keys, you get, some things. And that's a perfect time to collect your child. And
collect my child, you said?
Yes, to get your kid at the same time. So
she's not there. So that's the issue.
Oh, okay.
The child is mine, and she has to get her stuff too if she's not going to be there because my wife doesn't have custody of my child. It's my child.
But your child, who is not your wife's child, does have things at this place. Okay, that's fine. I'll say to collect belongings for you or for your minor child who is not also the alleged victim's child. Okay, I'm going to have to, now I'm hitting a character limit on these boxes, so now I'm going to have to...
My apologies.
No. It's something that's annoyed me for only 12 years.
I just wanted to specify because she's there as well.
It's important. No, it is important because the police are going to want to see my order, and they're going to go exactly with what it says. And so to avoid any confusion or, you know, a reluctance on the part of the police. I just want it to be explicit.
Does she leave the house?
No. Does who leave the house?
So yes, will my wife be leaving the house while the issue was?
Oh, the police are going to work that out with her.
Okay.
Meaning that's why a cop goes, because many times the alleged victims want to watch it happen so they can complain if anything is taken, et cetera. But that's why there's a cop there. Okay. The cop keeps the peace while one person collects their stuff and goes and stays somewhere else, excuse me. I'm going to put, I've got to shorten this up now, but it's going to take me a second, so I'll probably have you sit down. But it'll say, this order does not apply to any children you may have with the alleged victim. However, you're not permitted to violate it in order to exercise any parenting rights you may have. You may seek an amended order from the court in this criminal case, which won't be me, it'll be your trial court. But you may not violate the order in any way while you are awaiting a ruling on that motion to modify. So what I like to tell people, just to make it very, very clear, is, and I don't do it lightly, but if you can't figure out a way to do it without violating the court order, then you won't see your kids. Some people are extremely surprised by that. So you will not see your kids. It can be a felony to violate a no victim contact order in a criminal case. And certainly, if you are active duty military, you know this is already a problem for you professionally. If it turns into a felony, it will be potentially career changing.
It is.
It may already be, depending on your situation. And so you need to comply with all of your release conditions. And I don't take it lightly, Mr. Elliott. I give you as a point heavily in your favor that you're active duty military, you don't have any priors. What they allege is extremely disturbing, and it's public, which on the red flag list of domestic violence ramps the seriousness up considerably based on actual extensive research. People who are willing to do what is alleged against you in public are by simple social research, and by the way, common sense. Reading this, common sense. This one person, if they did that, is a threat to violate release conditions and commit new crimes. So I'm not taking this lightly. You should take it very seriously. The allegations against you are non-trivial, even though what is alleged only amounts to a misdemeanor. A lot of red flags for domestic violence. So just respect the release conditions. I gave you a lawyer for the bond. No, I didn't give you a lawyer. I apologize, because you're not indigent. You can hire a lawyer at your own expense. If you think you could qualify for indigency, you could fill out an affidavit when you get to Goodyear. Where is it? It's Goodyear. Goodyear City Court. But my understanding is they typically only appoint, in this kind of case, if the state notifies you that they are asking for jail time. And that is when then the court would give you a lawyer if you can't afford one.
Okay, so right now you said the bond was a certain amount.
$500.
And I
talk to the officers after court about how you can self-bond or what instructions to give family or friends who might come and post it for you. The officers will tell you exactly what to tell.
Sorry. Okay.
All right. I am going to have to twiddle this language for a couple minutes to make it fit in the stupid character limit. So give me a second, and we'll get it printed and sent out to you. Okay. You can go ahead and sit down. All right. Thank you. And Mr. Green, just stay where you are. I just need to type on this for a minute. It's good. All right. Okay. Mr. Green, you can go ahead and come in, and after that, it's going to be Richard Hall. All right, Mr. Green, can I have your full name and your date of birth, please?
Corday Gagdley Green, 0214-2008.
Okay, thank you. Mr. Green, you're here on a new case. You got arrested for third-degree burglary. It's a Class 4 felony. There is probable cause for it, and I am appointing a lawyer to represent you. Your next court date will be a status conference March 19th, which is 2 weeks from now at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be March 23rd at 8:30 in the morning, and the address for the court in downtown Phoenix is going to be on your paperwork. And it looks like neither the police nor pretrial services found any criminal or juvenile history for you. So as far as we can tell, it's your first arrest. So I'm going to release you under the supervision of pretrial services. You're going to get an envelope. When you get out, I want you to call the number. It has instructions. They're going to have you check in with them. Just follow whatever instructions they give you. They'll probably ask you some questions and then tell you what your instructions are. Do that. Do not miss your court dates. You will get a warrant if you miss your court dates, and then you're going to end up with a bond. Don't go to the scene of the alleged crime. That would be, well, it just lists the address, but it's 3610 West Baseline. So you can't go to the scene of the alleged crime. No contact with any of the witnesses there. No contact with any co-defendant you may have. You may not possess any weapons. No drugs without a valid prescription. No alcohol. You are under 21. Everything you need to know is on your paperwork. Will you do all of those things and come to court as ordered?
Yes, ma'am.
All right, then you are released. If you'll step to your left, I'll give you that information. Thank you. Mr. Holland, Richard Holland, and then Garrett Smith, will you go to the chair? I'm just looking for Garen. There he is. Okay, hi, Mr. Holland. Can I have your full name and date of birth?
Richard Holland, May 15, 1990.
Thank you, Mr. Holland. You're here on a new case. You got arrested for possessing narcotic drugs, a Class 4 felony, theft as a Class 1 misdemeanor, and criminal damage as a Class 2 misdemeanor. There is probable cause for all of those things, and I am appointing a lawyer to represent you. Your next court date will be a status conference, March 19th at 8:30 in the morning, with a preliminary hearing March 23rd at 8:30 in the downtown Superior Court. Now, in your case, I am going to release you to pretrial services.
Oh, thank God.
I gave some thought about putting an ankle monitor on you because what's alleged against you, among other things, the pulling out of a knife and stabbing the victim's tire right in front of her, alleged, tends to communicate a level of rage and willingness to perhaps escalate things that gives the court some serious concern about your potential for future domestic violence. That is an act that pretty unequivocally communicates rage to another person. But when I look at your priors, I've got a property felony, third-degree burglary, marijuana possession, and driving on a suspended license.
Yeah.
So I'm not seeing, I see some domestic violence. It was dismissed October 29 of 2023.
Yes.
So it's not nothing, but it's fairly little. So I'm not going to put an ankle monitor on you, but I am going to give you a status conference March 19th at 8:30, preliminary hearing March 23rd. You still get domestic violence type release conditions though, because the alleged victim is not required to live with you while this case is pending.
Yeah.
You're the one as to whom there are probable cause for crime, so you have to move. I'm just not going to put an ankle monitor on you to enforce it. If you prove that you won't follow release conditions, though, you're going to end up with considerably worse conditions and possibly a new case. I put the statute in your paperwork. It can be a new felony to violate my no victim contact orders.
Yes, ma'am.
Take them seriously. You can do a civil standby to collect belongings. Did you hear me tell the other guy about it? Okay,
Yes.
You can do that.
We already separated about 2 weeks ago. So.
Okay, all right. So you don't have any stuff to pick up. Okay, great. No weapons, no drugs, no alcohol. Don't contact the alleged victim. Don't respond to any contact from her. If you guys are in legal process, like serving somebody else with papers, not in person, because you can't serve papers in your own court case. Another person has to do it. But like I'm saying, if you're in court proceedings with this person, mailing them court paperwork or things like that, that's okay. But if you're not, then okay. Everything's on your paperwork. If you get served with an order of protection, comply with that as well. The info for pretrial is right there. So if you just take that come to court.
Definitely.
All right, everything's on your paperwork. Thank you.
Thank you very much, ma'am.
Mr. Smith, Garen Smith, and then Richard Hayes. We go to the chair. Good morning, sir. Can I have your full name and date of birth?
Garen Eldon Smith, 13187.
Okay, thank you. Mr. Smith, you're here on a probable cause arrest warrant, also known as a pre-charge warrant, that was issued, on February 23rd of this year, and probable cause was found for unlawful flight from law enforcement, a Class 5 felony, and reckless driving, a Class 2 misdemeanor, and looks like those were alleged to have occurred on February 23rd of this year. So I am going to appoint a lawyer for you. Your next court date will be a status conference in this case, March 19th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing March 23rd at 8:30 in the same court. Everything you need to know will be on your paperwork, and I am going to release you to pretrial services as well. You do have priors, and the police make out probable cause for an unlawful flight. However, in their factual description they included, it sounds like they absolutely know where you live. They'll come find you if you don't show up. So I'm willing to give you a chance to prove whether you will or won't come to court on this. If you prove that you won't, this is going to be a much shorter conversation next time because I'll just give you a bond. So comply with your conditions. They're pretty basic. No weapons. You're a prohibited possessor. Don't drive without a valid driver's license. Don't miss your court dates. Will you do all of those things and come to court?
I will.
All right. Then if you step to your left, you get your paperwork. Thank you. Mr. Hayes. And then Jackie Dukes, will you go to the chair? All right. Oh, and I'll probably, all right, Mr. Hayes, give me your full name and date of birth.
Richard Wayne Hayes, 27 June 1944.
Okay, thank you. Mr. Hayes, you're here on a new case. You got arrested for aggravated assault with a deadly weapon or dangerous instrument, which is a Class 3 felony. There's probable cause for it, and I am appointing a lawyer to represent you. You will meet that person at your next court date, which is going to be a status conference on March 19th, which is 2 weeks from now at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be March 23rd at 8:30 in the same court. And in this case, I am going to release you to pretrial services. Your case is not the kind that I see every day, and it looks like neither my staff nor the police could find any criminal history for you. And so you managed to make it fourscore. Well, you managed to make it fourscore with no arrests. And I did get a better description. The police didn't give a very good one, but, a short description of the fact. And it doesn't lead me to believe that you will be dangerous in the community while this case is pending. So right now you're not convicted. You're innocent until proven guilty. So we try to control for failures to appear and risk out in the community, including to be a specific victim. And so on these facts, I don't believe that you are likely to pose a risk to that person while the case is pending, nor to the community in general. But I am ordering you not to go to the scene of the alleged crime, which I think was a restaurant. Absolutely no contact with the alleged victim. You may not, at this moment in time, know his name, but no contact with him. No weapons, no drugs without a valid prescription, no alcohol. If you were served with any kind of order against harassment, you'd have to comply with that as well. Will you do those things and come to court on the 19th?
I certainly will. And
right.
Did you say you're appointing somebody?
I am, yes. But the way that they assign lawyers here, they're going to wait for the charging decision, meaning that now the county attorney is going to decide, because this is the police accusing you of this. It's not the county attorney yet. The county attorney needs to review the charges and decide whether they're going to basically take the case and go forward with the prosecution. Sometimes they can ask for more information, which means your case just doesn't go forward right now. They ask for more investigation from the police. There's lots of outcomes, and so the public defender's office, understandably, doesn't want to use resources to assign people to cases until they know that the county attorney is going forward with formal charges. So the county attorney now is going to get a good chunk of time in your case. It's been a while since I read the rule, but I'm going to say at least 2 weeks, well, not 2 weeks, more like 10 days to decide whether to proceed on the formal charges at this time, because of course there's a 7-year statute of limitations.
Right.
But they have to decide right now on this booking, are they going forward or not? And that decision will be made. So I did put a phone number on your paperwork. It's kind of buried because of the way our paperwork works. But I always recommend call a few days before your hearing. So the 19th is a Thursday. So maybe call that Monday or Tuesday, call the main court administration number and say, give me your info. Do I still have a court date on the 19th? If you do, you got to be there. If you forget to call, you got to be there. If they tell you, no, it has scratched, that means the county attorney did not follow through on this booking with a formal charge. So it's a lot to understand, but just, so that's why you're not going to, and we're going to give you a piece of paper for the public defender's office. You could call them if you want at any time, and maybe they'll tell you, we can get you to somebody. I don't know how they're handling it, but it's my belief that nobody's going to dig hard into your case to prep for it until they're sure that the charge got filed.
I got you.
All right, so everything's going to be on your paperwork. If you step to, if you give you a copy, it still takes hours to be released. Try to be patient, but you should. I tell people on this calendar, I hope you'll be out by dinner time. Good luck, sir.
Okay, thank you. Thank you, Judge.
Thank you. All right, let me do Mr. Dukes and Mr. Hundley at the same time, because pretty much everything's the same. Let's just close enough. I tell them right here. All right, starting with you, Mr. Dukes, what's your full name and date of birth?
Jackie Ray Dukes, 8/11/04.
All right, thank you, Mr. Hundley. Can I have your full name and date of birth?
Evan Travis Hundley, September 4th, 2006.
Okay, thanks. Can you guys hear me okay?
Barely.
All right. All right, you've both been arrested on the same charges, and Mr. Dukes, you got another special one added on to yours. So, you both got arrested for unlawful flight from a law enforcement vehicle, which is a Class 5 felony, and reckless driving, which is a Class 2 felony. Mr. Dukes, they have also accused you of driving under the influence of alcohol or drugs while impaired to the slightest degree. That's a Class 1 misdemeanor, but that's only Mr. Dukes. All right, based on what the police have presented, there is probable cause for these crimes, and I am appointing a lawyer for each of you. You know what, I just realized, it defaulted to public defender. So let me reprint Hundley. I got to change the lawyer assignment officer because they booked you separately. They didn't actually book you as co-defendants. But on these facts, the public defender can't represent both of you. We have to, the legal defender is a different public defense agency. And I'm sending you there, Mr. Hundley, but it is a public defender's office, and it's quite large because we are the 3rd largest trial court in the nation. So we have 3 public defender agencies before we ever get to court-appointed counsel. So anyhow, I'm just saying it's not inferior. It's just I need to send it to a different law firm. Okay. So both of you have the same next court dates. It's March 19th at 8:30 in the morning. Preliminary hearing, March 23rd at 8:30. Those are in downtown Phoenix. 2 weeks from now, the address is on your paperwork. And I just want to double check. It was hard to tell. Do you both work out there in by Wickenburg? You both work, or are you just living out there?
We live out there.
Do either of you work out here in Arizona?
We got booths for a living, yes, ma'am.
Okay, that's when I was scoping out. You seem like, because we see like the ranchy types from Wickenburg. Okay, so all right, and you're but I'm just trying to figure out. You're staying here for the foreseeable future?
For now, yes.
All right, are you planning to go off rodeoing in the next month?
Not out of state, no ma'am.
Okay, in-state is fine. How about you, Mr. Hundley? In-state? Okay.
In-state, yes.
All right. Then I am releasing both of you on your own recognizance. Neither of you has any criminal history that we could find. And so it'd be incredibly foolish to run from this, especially when that felony is probation eligible, even if you're convicted at trial. It's probation eligible. So I'm not going to lock you up before we even know that you're guilty. Right now you're innocent until proven guilty. So just come to court. Mr. Dukes, I think I said no alcohol for both of you, right? Because you're underage, Mr. Hundley. Yeah, so no alcohol for either one of you. Don't drive without a valid license. Don't have contact with the officers who arrest you, and just don't miss your court dates. All right, did you have a question?
No.
You just looked like, okay. Well, both of you do those things and come to court.
Yes, ma'am.
Then you're both released. If you'll step to your left, you've got your paperwork.
Thank you.
All right, thank you. Yeah. They are, yeah. Can you link them? Oh, okay. All right, so officer, she's going to actually link them as co-defendants because I guess we can do that. It works better for everybody. So it's just going to take a second to get Mr. Hunley's paperwork, because you're going to turn into co-defendant number 2. So, all right. All right, Mr. Salceda, where's Mr. Salceda? And then Carlos Olivas, will you go to the chair? Hello, sir, can I have your full name and your date of birth?
Sal Salcedo, 5985.
Okay, thank you. You're here on a warrant from Buckeye City Court, and it is for failing to appear and disorderly conduct. Those are misdemeanors, and this is 2 years old now, from March of 2024. I'm releasing you, so you don't have to tell me your excuse.
Okay.
What I can tell is from the sequence of the dates, it looks like a failure to appear on a citation, very likely.
Yeah.
And so I'm going to give you a do-over now that you see the fun consequence of missing a court date. Hopefully, you'd rather go to court, but if you don't, we'll see you back here maybe in 2 years for an ugly surprise and a bond.
Yeah.
So I'm releasing you, okay?
Okay, thank
It
you.
also says it's a noise complaint, so.
Yeah, it's for a modified exhaust.
So I don't know that you're dangerous. I just want you to go to court.
Yeah.
So arraignment hearing March 24th at 2 in the afternoon in the Buckeye City Court. The address is on your paperwork. As I said, I am releasing you because from what I can triangulate, it's a first failure to appear. Just please go. Because we will stick you with a bond next time, all right?
All right.
Reasons on your paperwork. If you step
Thank
to
you.
Thank you. Mr. Olivas, and then Ayana Moreno, will you please go to the chair? Hi, sir, can I have your full name and your date of birth, please?
Carlos Olivas, 9/19/93.
All right, thanks. You're here on a new case. You got arrested for criminal damage, a Class 2 misdemeanor. There is probable cause for it. I'm not appointing a lawyer for you because you don't financially qualify. You do have the right to hire a lawyer at your own expense, or you can represent yourself. Your court date is going to be in the Buckeye City Court on March 24th at 2 in the afternoon. That's almost 3 weeks from now. 2 in the afternoon, Buckeye City Court. Okay. Now, in your case, I did find probable cause, and I'm releasing you. And I'm going to leave it in the hands of the alleged victim whether she has contact with you, because what's alleged against you, while it's domestic violence both within the meaning of the statute, there's a statute about it, but it is the reason that the legislature included criminal damage in the list of domestic violence type offenses is because somebody violently smashing things in front of family members or people that they live with is frightening. It is an act of indirect violence, and it is an act of intimidation at a minimum as well. So it is a domestic violence offense, but in your case, you don't appear to have any criminal history that has been listed, located by us or by the police. And you're accused of damaging property, community property, which is what makes it illegal. You're accused of damaging property, not laying hands on somebody. And so that even if you did what they say you did, I don't know that it indicates that you're an ongoing danger to this person. She also appears to likely be reluctant to participate in the prosecution. It's not up to her, though. It's up to the Buckeye City attorney at this point whether the case goes forward. So be sure not to commit felony witness tampering by asking her not to cooperate in any investigation. That would be a terrible idea. But you can't have any uninvited contact with her. So and she has to consent to live with you. If she doesn't and you don't leave and the police get called, you're going to get arrested for violating my order. So you can't have uninvited contact with her. If she's okay with you being there, then the court is okay with you being there. No contact with the complainants or witnesses. That'd be whoever called the police. And certainly the court wants to protect those people from any retaliation, but also people who make those kinds of calls literally save lives. I've seen it here, that if they hear a domestic disturbances can turn deadly in an instant, if not just incredibly violent. So I always order no contact with the complainants. That's whoever called. You could still face a disorderly conduct allegation with them, but you don't at this moment. It's just criminal damage. Does that make sense? Does all of that make sense?
Yeah, it's just a little weird to me. It's my wife. We live together.
Well, yeah. You don't have to like it. You don't have to like it.
Yeah.
But if, and I'm not saying you did because you're presumed innocent, if people engage in loud domestic arguing and things get smashed, neighbors tend to get very worried that something terrible is going on and they should call the police. And, you know, I see a lot of people in here, I read some terrible things where people say, well, that's my wife. You know, of course I get to, and you didn't do any of this, but of course I get to do whatever I want. You know, that's my wife. That's my house. I get to do whatever I want. Yeah, so I'm not saying that's you, Mr. Olivas. You're just accused of smashing a vase, as I recall. But the idea that one person owns another person, or that one person's relationship with that person puts them above the law or in a different situation, is dead wrong. Just wrong. You know, well, that's my wife. If she doesn't know when to shut up, I get to smack her. That doesn't fly. That's assault. So, in any event, Mr. Olivas, what goes on in people's homes, to the extent that it involves crimes or starts impacting people out of the community, is going to end up in the government, you know, trying to invite themselves into your home. So you need to keep the peace with this person, and don't assume that smashing your own property in a community property state is not criminal damage, because it definitely is. All right, if you'll step to your left. Oh, by the way, also I do think that certain other domestic violence offenses could be, the elements could be met if you smash something that was unequivocally your separate property in front of somebody in order to frighten and intimidate them and express your rage. So everything's on your paperwork. I am releasing you. You need to know that if you don't comply, if she stops consenting to having contact with you and you don't get out, you could be arrested for violating the court order. Everything's on your paperwork, okay? Just take a copy.
Thank you.
Ms. Moreno, Ayana Moreno, and then Abigail Vanderkellen. We go to the chair. Right here, ma'am. Can I have your full name and your date of birth, please?
Ayana Lisette Moreno, 11/14/2000.
Okay, thanks. You're here on one new case and a traffic warrant. I'm going to start with your new case. You got booked in for allegations of narcotic drug possession, class 4 felony. Can you hear me okay? Yeah. All right. Drug paraphernalia possession and evidence tampering. Those are all class 6, so they're both class 6 felonies. So the narcotic drugs is a 4, the evidence tampering and paraphernalia are class 6 felonies. All right. This says you don't qualify for court-appointed counsel. Let me look. Oh, okay. Officer, I want to reprint hers. I'm going to give you a lawyer, ma'am. I didn't notice that by the algorithm, it says you don't qualify, but based on basic, you know, the standards that the court usually applies, I am going to give you a lawyer for this felony case, okay? Did I say your court dates already? Status conference March 19th. That's in 2 weeks. Preliminary hearing March 23rd. Those are at 8:30 in the morning in the downtown Superior Court. And in this case, just FYI, I did not find probable cause for any of these offenses. It does not mean they're dismissed, though. You are still accused of these things, and now the county attorney is going to decide what formal charges they may want to bring against you at this time. Okay. So you're entitled to be released because I didn't find probable cause. Also, I would have done that in your case anyway, because you don't have any felony priors, and these are drug charges. Okay. So I would have released you anyway, but in this case, you don't have any release conditions at all. You just have to come to court. Okay. All right. Now, in the El Centro Justice Court case, that is a driving on suspended license warrant. It's class 1 misdemeanor. The arraignment hearing is going to be March 19th at 9:30 in the morning. And I'll warn you, that is the same date that I gave you for the felony case. So you need to call El Centro, that's downtown. Call them when you get out and ask to reschedule your court date. Tell them you're double booked in Superior Court. They're supposed to give way. I can't change any of these court dates because I have no control over other courts' calendars. We're locked in to what we have to give you. I just try to warn people, you can't be in 2 places at once. Yeah. And so the misdemeanor court is supposed to give way to the Superior Court setting. I think this happens a lot. Just call them. The number's on your paperwork. Okay. But right now, March 19th, 9:30 in the morning. And I'm going to release you on your own recognizance. It looks like this is the first warrant in the case, or near enough that I'm fine. It's not a traffic case. So just go to court. You see what happens. You don't go to court. All righty. Everything's going to be on your paperwork. We're going to get you that fresh copy so it shows you get a lawyer. And did we give her the yellow piece of paper? Okay, thanks. Okay, thanks. Yeah. All right. Good luck. All right, Ms. Vanderkellen, and then Byro. Did Byro Barasa make it here? Okay, yeah. Okay, so wait, well, you can come up, sir. That's fine, and then I'll get the woman. Yeah. All right, ma'am, can I have your full name and date of birth?
Abigail Vanderkellen, November 28th, 1983.
Okay, thank you. You're on a new case and an arrest warrant. Okay, in your new case, you got arrested for possession of narcotic drugs for sale. That's a class 2 felony. Let me double check. I thought that was simple possession. Let me look. All right. It's thin, but it's not nothing. So yeah, all right. I do find probable cause for that. The police were very non-specific about what a large quantity means to them. Let me just double check. Yeah. So they did book it as for sale, and there's probable cause for it. That's not a terribly high standard for the sales thing. So talk to your lawyer about that. It's a minimal showing as far as I'm concerned. Mm-hmm. All right, I am appointing a lawyer for you. Your status conference will be March 19th at 8:30 in the morning with the preliminary hearing March 23rd at 8:30 in the morning. Now, you're also here on a charge that was filed, as I recall, late last year. Hang on. There's been a criminal complaint filed against you, charging you with theft of a means of transportation. It's a class 3 felony. The alleged offense date is back on May 21st of 2025, and it looks like this warrant went out last November. So that charge is also now pending against you. I'm going to give you the same court dates and a lawyer, so you'll have the same lawyer for both cases. Your next court date for the theft of means is also March 19th, 8:30 in the morning, with the preliminary hearing March 23rd at 8:30. And in both of these cases, you do qualify for release on your own recognizance. Now, the theft of means is not a new case, and the drug case, as I said, it's the allegation, what the police allege is their proof on the sales element is pretty minimal. So I'm going to go ahead and go with the release recommendation. You need to come to court. You have 2 problems, different cases, but it looks like you also don't have any felony priors. So get yourself to court, comply with your conditions. Don't have any contact with the alleged victim in the auto theft case.
Okay, yeah, because they originally, when I called to come to court for that first case, they had dismissed it. So, and then I moved and
and it's just I described it to somebody else. It's the county attorney didn't go forward right then.
Okay.
But maybe they asked for more information or whatever, and
Gotcha.
so they filed it later. That does happen to a lot of people.
Okay.
So talk to your lawyer about all of that. Just in the meantime, don't miss any court dates. Don't have any contact with whoever owns the allegedly stolen car. Okay?
Yeah.
Everything's on your paperwork. Will you come to court and comply with those conditions?
Of course.
All right. If you step to your left, you get that paperwork.
Thank you.
Thank you. All right, Mr. Barasa, and it looks like we got Mr. Palmer in here, so you can go to the chair, sir.
Yes, Your Honor.
All right, Mr. Barasa, can I have your full name and date of birth?
Bayer Barraza, August 29, 1999.
Okay, thanks. You're here on a new case. You were booked in for allegations of possession of a weapon by a prohibited person. It's a class 4 felony, and failure to admit the carrying of a deadly weapon in your vehicle or concealed on your person when asked by a police officer. That's a class 1 misdemeanor. There is probable cause for those, and I am appointing a lawyer to represent you. Your next court date will be a status conference March 19th, which is 2 weeks from now, 8:30 in the morning in the downtown Superior Court, with a preliminary hearing March 23rd at 8:30 in the same court. Now, the county attorney requested a $25,000 secured appearance bond for you. I know why they did that. It's because your priors are for aggravated assault and assisting a criminal street gang back in 2017. So 9 years ago, you were convicted of that, and you did 3.5 years in prison. That's why they're asking for it. Now, I will say you appear to have been crime-free since your release from prison, and the facts alleged against you in this case, they're not nothing. They are probable cause, but they are not the strongest ever on this type of charge, and even if they were stronger, the evidence doesn't indicate that you were, at that moment in time, doing anything particularly nefarious with the gun other than possessing it. So on all of those facts, I'm going to release you to pretrial services. It looks like the police took your buccal swabs to try to run DNA against the weapon, etc. It's also entirely possible that the county attorney's office will, when they look at this for charging in a few days, they will decide to wait for those results. So did you hear the lady who said my case was dismissed and then it came? So this case may go away for a while, and then it may get filed against you later, like if they're waiting for DNA results.
Prejudice, right?
What's that?
Without prejudice?
Right. So it's not really so talk to your lawyer. It's a little bit, procedurally speaking, it's not identical to that, but it's the same idea. They have a 7-year statute of limitations to charge you with this. They don't have to do it right now, but if they don't do it right now, these court dates and everything are going to go away. So the county attorney needs to look at what the police give them on your case and decide whether they want to go forward right now or whether they want more information, like DNA results. So there are many possible outcomes. Right now, I believe the right decision in your case is pretrial services release. But you need to be very careful to comply with release conditions. No weapons, you're definitely a prohibited possessor. No drugs without a valid prescription. Don't miss any court dates, okay? And call into pretrial services. We're going to give you an envelope. When you get out, call in, just follow those instructions, okay? And don't miss any court dates.
Okay.
All right, will you do those things?
Yes.
All right, then you are released. If you step to your left, you get a copy of that paper. Thank you. All right, Mr. Palmer? Hello, sir. Can I have your full name and your date of birth, please?
Michael Douglas Palmer, 9/21/87.
All right, thank you. Mr. Palmer, you're here on 1 new case and 3 probation holds. In the new case, you were arrested for 1 allegation of third-degree burglary, that's a Class 4 felony, and 3 allegations of attempted third-degree burglary, which are Class 5 felonies. These are all alleged to have occurred on February 8th of this year. I am appointing a lawyer to represent you. There is probable cause for all of those crimes. Your next court date will be a status conference March 10th at 8:30 in the morning, which is 6 days from now, with a preliminary hearing March 12th at 8:30. Those are in the downtown Superior Court. Now, you are on probation for 3 separate felony offenses. You are currently already in revocation proceedings in those cases, but the probation department will be filing supplemental petitions to revoke your probation in all 3 cases based on this new arrest. So you get copies of those from your lawyer. You'll have a lawyer appointed on those petitions as well. Your next court date in probation court, I didn't look up what your next one might already have been, but for this new supplemental petition alleging the new crimes as violations, you're going to have a revocation arraignment hearing on March 11th at 8:30 in the morning. So all the court dates I'm giving you are next week. March 11th at 8:30, it's a revocation arraignment hearing. And pursuant to Rule 7.2C, the court finds that you will, in all reasonable probability, be revoked to prison in 1 or all of your probation cases. So you are held without bond in all 3 cases. You do not have bond. In the new case, you have a $50 secured appearance bond. That's to make you eligible for credit for time in custody, since you're going to be in custody. You do have written release conditions in that new case, which will apply if you are out of custody at any point. Do not go to the scene of the alleged crimes. Don't contact with any of the alleged victims. No weapons or drugs without a valid prescription. Call your PO within 72 hours. But you are still held without bond in all 3 of your probation cases. Everything is on your paperwork. If you step to your left, he's going to give you a copy. Thank you. All right, no house calls, huh?
No, Your Honor, on Mr. Elliott.
Yeah.
I wanted to clarify something about the waiting not to go because his vehicle is there.
Okay, all right, Mr. Elliott, you can go ahead and come back in, sir. Where is that? Okay, right here. So just so the microphone picks you up, sir. Okay, what was your question, sir?
So my questions were, my vehicle's at my home.
Okay.
And she's in the home.
Right, so you still have to do the civil standby.
To
meaning,
get my vehicle?
Yes, if you have the keys yourself.
I do.
And you have a friend with a driver's license who could go get it for you peacefully and just basically get the car and go, that wouldn't violate your release conditions as long as they just got your car and left. And
what would violate it is if I go to the car and drive off.
Yeah, you can't go.
I can't go to
cop. You have to bring a cop with you.
Okay.
But
I
so
have
when
a gun in the glove compartment. This also said no weapons.
Right.
There's already a
so you have to get that into somebody else's possession where you do not live. And so I don't know if a friend can take it for you. You can surrender it for holding at a local police station.
I can't leave it in my house?
If you bring the cop with you on the civil standby,
I'm sorry.
You could ask, if you bring the cop with you, you could ask the cop to put the gun in the house if the alleged victim will have it there. She may not want it there.
There's already weapons there.
Well, yeah, you won't be there though. So the cop's not going to let you collect weapons from that house. But what I'm saying is the cop could facilitate and or maybe be willing to just take it into the house and secure it with the other ones in the house.
Oh, okay.
But with children in the house, I hope they're extremely well secured.
They're locked.
And so if the victim is okay with it, you know, the cop could say, great, we're going to put it in here, we're going to lock it up, and then the cop can kind of supervise that whole thing. As long as they're there, you know, watching the whole thing, then that should go fine.
Okay.
But, yeah, just, right, be careful to, you know, do it in a way that where you could, you know, you've got a witness, how you did it, and I think with the cop being there, if the Goodyear officer's there, I mean, just let them know when you call. You can say, I need a civil standby. I need to tell them what you need to get. My belongings, my kids' belongings. I need to get my car. FYI, the court ordered no guns. There is a weapon in the glove box, so I would need assistance getting the weapon out of the glove box and into the safe in the house. And hopefully the alleged victim will consent to have that one added to the safe. If she doesn't, I don't know what the cop may do. They're going to just try to keep the peace, and you know, that's literally why they're there. And I always emphasize, try to be as nice as you can to the officers. They'll probably give you more time directly related to how nice you are to them. So, but it's my understanding from what I've heard, it's probably 30 to 60 minutes is the max you could expect the police to give you.
Okay, and then I know I'm asking a lot of questions. I'm sorry, I'm ready to go. I don't understand if I'm hearing them release. I've never done this before. I'm hearing people release, not release.
I know, you don't like your outcome.
No, I don't know what it is.
So you could re-argue it, but listen.
With you?
No, I'm just saying, well, theoretically, no. Your case is done, Mr. Elliott, and I'm not reopening it. But I understand that you want to understand. You are accused of different behavior than they are. And the behavior of, and this is the thing is, I don't want to debate what the cops allege because I don't decide whether you did it. I assume you'll have a different story. And so, but probable cause is a test of what the police gave me. We do not conduct a mini trial.
Okay.
So I will tell you what they accuse you of. I am in no way opening up a negotiation to you saying, I didn't do any of that.
I understand.
Because I think you probably would dispute a lot of this. But what they allege is there's an argument, she goes out for a walk. While she's at the park at 1:30 in the morning, that you arrived, began to chase her across the park, grabbed her, threw her down to the ground, began to forcefully open her mouth with your fingers in her mouth, making remarks about the argument. Then you became apologetic, made a mistake. Then they say there was dried blood on the victim's bottom lip, and they have a speck of blood on the chest area of your sweater and a speck on your finger. It was observed that you did not have any personal bleeding injuries. And so that's what I'm talking about, the idea of a person who you have not been convicted of being that person who would hold down their loved one and forcibly jam their hand in their mouth. That is a particularly invasive assault. It is a demonstration of domination and control that tends to indicate future domestic violence threat to that person, a risk of intimidation or retaliation. If you did those things, right now the court has to control for risk. If you had any violent criminal history, your bond would never have been as low as it is.
Okay, I understand.
So this is the low bond that a person with no criminal history who appears to have a good job, you know, serving their country.
14 years, yes.
This is the bond the person with the good criminal history gets, because I've done this for many, 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 many years. The type of behavior that indicates is a big red flag. It is a big red flag. That is a particularly invasive kind of assault.
I understand.
More so than a slap in the face. And none of the people who got OR'd were alleged to be hands-on. Not one of them. That was criminal damage, and one guy, didn't love it, was accused of popping his soon-to-be ex-wife's tire with a knife right in front of her. He had no violent priors. So, and waited around, talked to the cops. Everything was fairly calm, apparently, while they all waited for the cops. So, on balance, all of that. What's alleged against you carries an inherent idea of domination, control, and a willingness to commit a particularly disturbing type of assault. And so that is very suggestive of future violence and, frankly, of past violence. None of that is beyond a reasonable doubt. That is probable cause. Probable cause is not even preponderance. So please talk to a lawyer about how all of that works.
Okay.
That is why you got a bond. I can understand why the facts might not appear to line up with some of what you heard, but none of the people who got accused of hands-on offenses got released. One of them got a $50,000 bond. There was a DV guy who got $50,000.
I was just trying to understand.
And so that one, the court is extremely concerned that the next assault will result in the victim's death.
And I understand.
And so,
I understand.
Hopefully,
Clarifying.
we'll try to place it on a continuum as best we can.
I understand.
All right, thank you for your time.
I'll call the order.
Okay, thank you so much, officer. Have a great day. All right. What's that? Yes, we're going to stand in recess till 2 p.m.